I seek my lordship to mention one matter. Yes, my lord. This matter is my lord has delivered the judgment yesterday, my lord, but no appearance has been recorded for.
Appear in the list has to be mentioned. Or
My lord, no, my lord, may I be permitted to mention a matter? And then my surname is ROY. Here is
which case? Item 2.
item. It's Philip Sidney Wilson versus Surya.
The list.
Yeah,
No.
If the slip will appear on the next day.
Sleep down.
স্লিপ দিন তো দাদা ভাই বড় কাগজ দিন
In item number 1, I am appearing on behalf of the executives. Lordship, all GA was disposed of. Last occasion, your Lordship, after hearing the matter, was pleased to direct the department issue general citation and also direct to make paper publication once in the Statesman and once in Anandabajar Lordship. The citation was received by me ultimately on 28th May, and
April 28th, the order was passed.
subsequently citation was received by me on 28th May.
Taken steps.
I have taken steps, initiated the paper publication will be done tomorrow, Lordship. So in that case, I am praying for just fortnight adjournment in the matter.
Advocate for the petitioner and prays for time to take necessary steps in terms of order dated April 28th. Matter stands adjourned till 8/7/2025 for taking necessary steps.
Lordship, one thing more, this matter is non-contentious, but in the cost title, it is appearing in the goods of Minoti Banerjee versus Priyobroto Thakur, Lordship. The versus Priyobroto Thakur is myself.
That can be rectified on the next day, 8th of July. Not correct. Yes, item 2.
No, Lordship. My Lordship, I have put 3.
Yes, my lord, I appear on.
All applications are to be heard out.
Yes, my lord.
Except GA4 or the other
Yes,
applications.
it is not there. It is not there.
You are appearing in GA4.
GA4 is the main application,
Yes.
out of which all these applications have arrived. GA4 has not been given. I do not know why, my lord. My lord, your lordship, another thing. My lord, your lordship, kindly seize the list. Item number 3,
Yes, yes.
GA5 2023.
Yes.
Then petitioner's name is Sam Nadali. I am not.
No, GA5. The petitioner's name is mentioned as Abdul Khair.
No, petitioner's name.
No,
It is the cost title.
My lord, this is an application for addition of party. And in relation to this, may I submit
If
one
this
thing?
is an application for addition of party, there must be an applicant. His name will appear in K instead of Samjad Ali.
the plate.
No, my lord.
My lord.
No, I'm gonna make
May I give you a little bit of the
main case. Main case is of 1942.
42. It is no longer there.
Yes.
decree has already been done.
Yes,
The scheme has been built.
yes.
Out of that scheme, my lord, the entire work property has been taken under the management of the court,
Yes.
under a scheme framed under section 92 of the civil. Formerly, there was a special officer, appointed. Myself was the special officer. It is long back. My lord, I have taken possession of all these properties. After I took all these properties, what were the cases for? Cases were for the malfeasance and misfeasance created by these in Matwalis in collusion with the Board of Authors. So that is why, my lord,
What is the main application for? GA4?
the GA4 is, my lord, when there is a committee that has been appointed by your lordship.
Yes, so what?
In that committee, I am the chairman and two members are there, one representing the Board of Work, one representing the working. Now, my lord, certain properties that is still now is not, my lord, it is just occupied by the occupiers. Like this GA5, GA6, GA7, all these people.
Would be considered on its own merits, okay?
Yes,
But let GA4,
we placed
GA4 is for any scheme, any further modification.
in all this. GA4 is all this, my lord, has been given. That these are the scheduled properties which is now under occupation. These are the properties which the occupiers have agreed that they should accept the
Related to all GA4.
all GA4.
Lordship,
You have served with a copy of GA4.
lord, may I
You are
submit-
the intervening
Yes, I am the
application.
intervener.
I am the intervener.
You are not a party.
My lord, may I take up one particular thing? This, the Abdul Khair and Nasir Hussain, a long date.
Yes.
I fail to understand how application.
Unless steps are taken to rectify the cost title.
My lord, this is the prerogative of my learned senior friend. He has not taken. And
Yes,
moreover,
taken.
had it been
It cannot
Advocate
be,
General,
it is not needed.
had it been Advocate General of West Bengal, then it would not have been needed.
My lord,
But
this
since
scheme
it's
has
an
been given
individual
to
name, that has to be rectified.
My
And
lord, this
moreover,
scheme-
my lord, kindly come to 11 July 2023. This order for the first time has visited my client that says, by the help of officer in charge Park Street Police Station, we will be thrown out without serving any notice, without giving any opportunity to us. My clients who are the tenants for the last 4
If
decades,
petitions come,
out of
all
hibernation,
these allegations I will put to
Applications will be taken up later.
Lord, we will say
Mr.
that.
Ali's petition comes.
Yes, all the applications.
Lord, I am beg to appear on behalf of the above board. We have made an
Which
application,
application is yours?
GA11.
G11 it's appearing, yes.
Yes,
Item 9.
yes.
Yeah,
I need to be added as implemented as a party because I am the board of work.
Opposition to all these applications.
My lord,
All.
And this
I
is
have
the affidavit.
I have filed my affidavit in opposition in GA4.
You keep it with you. Let the other.
Lordship.
Lordship. Yes.
My lord, GA10, my lord, is my application. I'm a tenant, my lord, in the property. Now, my lord, I have filed my application till date. No opposition has been given, my lord.
And my lord, in GA4, my lord,
GA10. GA10.
and my lord,
What is the name?
lordship, I have
Has been
filed
given.
my affidavit in opposition to my learned senior friend's GA4, my lord. I appear on behalf of Mr. Abdul Rashid, my lord, who's
Yes, I have.
wherein my learned friend has ventilated his allegations against me, my lord. I have filed my opposition, and my learned senior friend has filed the reply also, my lord.
If affidavits are already exchanged, let it appear as chamber application adjourned.
No, my lord, in the meantime, my lord, let GA4 come. My lord, it is the work property that is suffering too much.
Learned advocates for the parties are present as these applications are G4 of 2020, G4 of 2000.
Yes.
2023.
23, it is not appearing in the list. The matter,
In spite of the order.
as the papers are not in court, in spite of the order, let this matter appear on 1st July 2025.
Well, let it be a little early because one of the some properties are there which is under the occupation of the occupiers, and for years to be Godiad property, Godiad market.
Only just 10 days.
10
okay.
days.
Let the records be produced in court without fail. Affidavits to the applications, if not filed, may be filed.
Lord,
If you have not filed
I
any
will show
affidavit,
that I have given. But if anybody has not filed any
Apply.
wakalatnama, without wakalatnama appearing, let them file their wakalatnama. I will show that many persons are there without filing wakalatnama intervening.
you have not filed your affidavit or
Oh.
wakalatnama, please. take the
Lordship, we have
necessary
filed
time
it, we have
and
filed our opposition. My learned senior friend has filed the reply also. There is no question of not filing
Not filing,
wakalatnama.
right?
No question of.
Well, while
No
I'm
question of
making
not
statement
filing
to the court,
wakalatnama.
I'm sure, my lord, that I am making a responsibility.
Definitely.
At least not in my case, my lord.
Yes,
I have
the
filed my
senior person,
wakalatnama.
we
I know
respect
who
it. All three are on the same date. সবকটাই সেপারেট অর্ডার করে দেয় কোনো একই অর্ডার হবে এক থেকে 10 এই না 3 থেকে
3 to 10, my lord.
Let the list be correct.
3 to 10 কেন?
Because the applicant's name,
আপনার ওটা বলে দিন, তাহলে আপনার ওটা
all
বলে
to
দিন।
appear with GA4 of 2023.
with the corrected list, my lord, because the applicants are different.
Yes.
In GA5 application is different person.
G11 is my application.
The court has to go through the context, okay? If some rectification is to be
On
made,
the next,
he
that is the department's or registry's card.
will be granted to rectify
Lordship.
or direction will be issued.
Lordship.
It is the registry, they will do it. It is not the court will do it, my lord.
It is fault of the party will be granted liberty.
Lordship.
No, it is not the fault of the party, my lord. I am pleading for them because I am the court officer, my lord.
Very
Yes. I'm diplomat. I'm sorry, my lord.
okay.
My lord, item number 11, I on behalf of the decree holder late by Shaurojit Dashgupta. He is on his legs before courtroom number 19 matter is going on, my lord. My lord, I am praying for not to.
Not today.
Not.
I'm making it just not today.
And not this week, my lord.
This week is Thursday. Chamber matters are taken up on Tuesday and Thursday.
Yes, fine.
Not,
Yes,
not
yes,
today.
yes, yes, fine. Well, I'm good.
Grateful, my lord.
Real
To
lordship.
same
Same,
matter,
not today.
same.
Yes.
Grateful.
I appear for the decree holder, your lordship, in pursuance of your order that is 6th May, a special officer was appointed, your lordship. The special officer,
Thing is appearing.
I'm happy, I'm the advocate of the court, I'm Rahul Singh, your lordship. I'm the advocate for the decree holder. Shyam Sundar
Yes.
Mukherjee.
That day, Mr. Rahul Singh appeared.
Yes, your lordship, I had appeared. And Rakul Das had appeared, your lordship.
But on the last occasion, the report was not filed.
Yes,
The
sir.
date for filing the report.
Your lordship, the special officer has come. He has come. He was due to file his report, your lordship, and he was also seeking a further time to complete. He was to file the interim report, your lordship.
I make it not today.
Okay, your lordship.
Item number 14, my lord, I appear for the decree holder in a counterclaim, my lord. The matter was, your lordship recalls, my lord, that the judgment debtor, my lord, had appeared and they had indicated that they had preferred an appeal. Now, my lord, that particular appeal my lord, is now to be listed in the month of September. They have not even got there, which was dismissed for default, my lord, and thereafter not restored.
Last page
That is the order, my lord,
by the division bench.
by the division bench. Your lordship had granted a last opportunity in favor of the judgment debtor to get an appropriate order from the appellate bench, my lord. From the appellate court.
That has to be proceeded with.
Yes.
Yes, yes, the judgment.
Your
You
lordship.
are appearing.
Yes, your lordship.
So have you obtained any order on 10th June? This matter was.
Your lordship, we had
No.
mentioned as we have already apprised your lordship yesterday only. We had
Appeared on 10th June. I adjourned it for a period.
yes,
of
your
nine-
lordship.
9 days.
The same in this matter only the application for mean profit yesterday which appeared. We had apprised your lordship.
That is
that we
irrespective
had-
of, my lord, the execution
is- that
proceedings which
we-
is pending before your
Yes.
lordship.
But that we had already apprised your lordship that we had
Yes.
mentioned it. It came up in the hearing.
There is
That
no change
the
in
honor-
position. Okay.
Absolutely.
as of now it is not because it appeared
In
in
fact,
the list.
on the last
the
occasion, my
honorable
lord, last Thursday, the honorable division
restored it
not
because,
even pleased to restore it.
but not rejected, your lordship.
obtained necessary orders, but from the date 10th of June till today, there is no change of the.
And my lord, there is no appeal pending as on date. There is no appeal pending as on date.
The honorable division bench was
Obviously,
not,
he has not
uh,
restored the appeal.
issued on that day because we
That
did
is the
not
order which I have
could
handed
not-
up to your lordship.
Approach again. Yes,
We
what is
could
the
not obtain an interim order.
Yes.
Then your lordship kindly allows me to
Decree,
file
my
an
lord, is
opposition to
for
this.
eviction.
Kindly allows me to
What
file an
will be an
opposition.
opposition, my lord, to an execution proceedings?
Yes, of course.
Of
Why
course
not?
not.
Is there any interim order?
No, there is no interim order. That is what I'm seeking for, my lord.
Your lordship.
Interim order that I've prayed for, my lord, is your lordship may
Your
find it
lordship.
from the tabular statement, my lord.
Your lordship kindly grants me
Column
an
10, my lord, is my prayer.
grants me an opportunity to file
Your
an
Lordship, this is, your Lordship, may I please, your Lordship? Your Lordship, this is that matter by which your Lordship, yesterday, your Lordship, remembers have adjourned till 3rd of July because the appeal is pending.
That was
And
the
we are
main
taking
profit
steps to
application,
mention the
my lord,
matter.
not the
On the
execution
same
proceeding.
matter. Same matter.
This is an execution proceedings.
No, execution proceedings from the
Yes.
appeal itself. Your Lordship, in the execution only, they have made an application for calculation of mean profit.
No,
Your
no.
Lordship
It's in the-
remembers I appeared
Perhaps
yesterday
not
and prayed for
appropriately
time,
explained, my lord.
3rd of July.
The court will confine only with regard to the
Execution, yes.
Correct, your Lordship. The appeal is here. The appeal is there. It was
There's no
dismissed for
appeal
default.
pending, my lord. That has
No,
been.
it was dismissed for default.
Has not been
I
allowed.
made an-
The appeal restored till date.
on the last.
No. Yeah, we are mentioning the matter
Granted in
today.
favor of the judgment
On
data.
the last,
Restoration application is pending.
maybe you get it restored, get it.
It has not been
That's
restored.
why I was humbly praying if your Lordship gives us time
For the honorable
till
division
3rd of
bench,
July.
the honorable division bench has not granted any
The
opportunity.
other application, Honorable Division Bench has not dismissed my restoration petition. Restoration petition is pending. It is not dismissed.
Get this order set aside. Yes, what is the
So I
interim?
was humbly beseeching if your Lordship kindly grants us time till 3rd of July. Because the
The
other matter is also posted on 3rd of July. We are mentioning the matter today in the afternoon.
I'm considering the interlocutory application.
Yes, my lord. At this juncture, my lord, perhaps interim order, we are seeking for the execution of the writ of possession, my
Your
lord.
lordship, there is no interlocutory order. Application.
How
No, not.
final order he is seeking at the interim stage. If he seeks for writ of possession, then my appeal becomes infructuous.
They have not been
I
able to proceed with the appeal. They have not got
We
any.
have been able to proceed. It was dismissed for default. This can happen with
Recurring
anyone.
application has not been
Mr.
allowed.
Sengupta, this
Nothing remains on their.
Today,
dismissal
I am
for
reading
default
Mr.
can happen with anyone.
Sengupta.
At this
There is
If
a
juncture,
today
restoration
we do not
petition
get
which is
the
pending,
decree,
that has not been dismissed.
if we do
Today
not
the
get
writ of
possession
possession is
today,
executed, I am out of possession.
but Mr. Orik
Final
Banerjee
order
can
in
go
execution.
on and on and on. You go on and on and on. But the matter remains that he does not have any stay, he does not have any appeal today in the eye of law. How can, on what basis can he resist my taking over of possession? He does not even have a, my lord, appeal. Forget about it, stay.
Writ of possession cannot be an interim order. That's a final order, and if that is
My lord,
executed, I'm out of
I do
possession.
not wish to
appeals become
advise him.
infructuous.
My lord, kindly, my lord, give me possession. If required, if he can get
No,
the
there's a
appeal heard out,
restoration
if he can
petition pending.
restore the appeal,
That has
my
not
lord,
been
let him,
dismissed
my
by
lord,
the
take
division
steps.
bench.
My lord, enough
That
is
has not
enough.
been dismissed. That
If
has not been
if
dismissed.
this is the way this court is to function, then my lord, no sanctity
So
of
I am
orders will
humbly
be there.
beseeching, give us the opportunity to get the appeal restored. Restoration petition is pending. We have given a mentioning notice. We are
My lord, the
mentioning at
appeal
2
court has
o'clock.
specifically not allowed him, not was inclined to restore the appeal and not interfere. If your lordship thereafter gives them any leave to, my lord, does not execute the decree, my lord, it will be travesty of justice.
It is an admitted
Specifically because of
position.
their conduct, the appeal court has said that I will not interfere.
Conduct
And
is
even the
on the
appeal is not
occasion that I
restored.
could not deposit the money for stay. I am not asking for stay today
So you go
because I
up in appeal to the
am not in the
apex
financial
court.
position to
Please
deposit.
please go and carry an appeal to the apex court from the order of the
No,
division
my
bench.
restoration
But you
petition is
cannot,
pending. Why will I go before the apex court?
my lord,
My
I
only humble prayer
cannot
before
carry on
the
like this.
court is
I
that
leave it to your lordship. My
kindly
lord, there is
adjust the
no
proceeding
stay.
till
There is
3rd
no
of
appeal in the eye of
July.
law. 2 months have gone by. Kindly, my lord, execute the decree today. Let
I
him
am
go to the
only-
apex court and get an order.
My only request is that kindly take it
Has
up after
not
3rd of
disclosed
July.
No, I am opposing that. Kindly execute the decree
matter
today.
will appear before the learned appellate. The order dated 10th June 2025, it appears that on the prayer of the learned advocate for the judgment dated, the matter was adjourned till 19th June 2025. granting opportunity to the judgment debtor opposite party to obtain necessary order. But as of today, the position is the same. No specific order from the appeal court by which this court will further adjourn the matter or stay the proceedings. In hearing the learned advocates, this court is of the view that necessary order should be passed. Thus, the position
No, sir, I was seeking one more opportunity till 3rd of July.
judgment debtors their main
to Get
business
the appeal
of
restored.
the court.
in occupation of the property of the suit premises, recovery of harsh and the sheriff take necessary steps and submit the report. Stop. Let this matter
My lord also provides, my lord, in the event of any obstruction.
come afterwards. Okay? That will come afterwards. If there is a report, I shall consider.
Yes, very well.
Let this matter appear on 15
My
2025
lord.
report of the sheriff. Stop. It is, however, made clear that the parties may think fit may obtain necessary orders from the appeal court on or before
My lord.
3rd July 2025 until date this order shall remain. Stop. In the event no specific orders are obtained on or before 3rd July 2025, the sheriff shall proceed and implement this order.
Grateful, Your Lordship.
That may also record the schedule of the premises, my lord, which is there right at the next page, my lord. The next page, my lord, of the tabular statement. Yes, my lord.
ইয়ে করে দেবেন vacant possession of the suit premises being suit premises being mentioned in the
Schedule of the tabular state.
the tabular state. Yes, take necessary steps before 3rd July.
Grateful, your lordship.
Great.
My lord, regarding item number 13, I am here just
It is
outside.
not today. You are not. I was informed that you are not ready.
My lord, I am ready. I am ready. I am submitting the report. I have been
Your
appointed.
report is
I-
complete.
Complete, my lord. Lordship.
Yes, sir, I will serve with a copy of the report just now.
Yes, the learned special officer is present and submits his report. Let it be kept with the record and a copy be served upon the learned advocate for the decree holder. Let this matter
Your lordship,
appear on
Bolji.
3/7/2025 for consideration of the report.
Your lordship, I was just informed by him that he needs further time since two of the partners had passed away, your lordship, in this report, what I have come across, your lordship.
Then I'm keeping it instead of 3rd July, I'm keeping it on 15/7/2025. 15th of July.
Yeah.
July.
It will take time.
Your lordship,
You are
he needs,
getting- you are getting
Two times visit. I have 2 times visit.
You are
Please,
getting-
it will take time, my lord.
Oh, no,
Kindly-
there's a
kindly
26
three-
days.
3 weeks. Kindly
20
3
no,
weeks.
no, you are getting 26 days, you see.
26.
Today it is 19th.
Yes.
I'm keeping it on 16th of July. The 15th of July.
your lordship, may a further report be also be called for?
And further report may also be submitted by the special officer upon inquiry. Let a further remuneration of 100 gems be paid to the learned special officer.
Grateful. I paid the earlier remuneration.
Pay further remuneration.
Yes,
of 100
yes, we shall.
15 সাথে 15 সাথে appear. Okay, I'm just keeping it on 22/7. Let it be kept with the record.
Great.
Let's cable for it.
I'm grateful.
Yes, give your name.
Item number 15, my lord. Mr. Jit Roy is appearing for the judgment date, my lord. I'm praying for not today, my lord. I'm instructed.
No, my lord, I'll just indicate, my lord, the execution proceeding has been stopped because of this application for dismissal, my lord. And in the last occasion, my lord, the petitioner had completed the submission. Let me continue. They can give a reply on day after tomorrow or any other day, my lord.
My lord, I am for the petition.
My lord will see, my lord, second last order. My lord has said in the meantime, execution is not to be proceeded with. I have a money decree in my favor, my lord. I have
One thing, instead of submitting today,
very well.
let's send you written notes on the next day. I shall conclude it.
My lord, I have
All affidavits are complete.
affidavit are complete. They have had one full day to address, my lord. I was also.
It is a maintainability petition.
Yes, my lord.
It is a maintainability petition
You
which is
address-
not maintainable on the face of it.
Address with your written notes. It will be easy for them. I'm keeping it on Tuesday.
Very well, my
Next
lord.
is the-
It's for the parties are present.
Not today, sir.
Time is sought for on behalf of learned advocate for the judgment dated. Such time is granted in the interest of justice.
I'm full.
Learned advocates are requested to come with their written notes of argument. for the next day. Come on Tuesday with your written notes. Tuesday.
Whatever your lordship, I'm all ready. If he wants to move it, he can move it because it's my application. Your lordship has heard it substantially.
No, it is the petitioner's application for dismissal, probably.
Judgment
In
debtors
the
application.
judgment
That is
debtor's
judgment debtor's
application for
petition.
dismissal on the ground of jurisdiction.
So they have concluded.
Yes, sir has
I
concluded.
have concluded.
I will reply.
Oh, right. Right.
I have
You are from
concluded.
the judgment.
Yes,
debtor
I have
petition.
concluded
You
my
have
sub.
concluded, he has to reply.
He has to
I have
reply.
both of you to come with written notes.
Whatever your lordship.
Tuesday.
Can it be Thursday, my lord?
This is with regard to jurisdiction.
No, because preparation.
I have heard this matter. I recollect. Okay.
It will recollect me.
I heard this matter. Please come with your written. notes.
Very
It
well.
will
my
not
lord. We'll
take
do
much
that. We'll do that.
এটা ইয়েতে করে দিন এই সামনের মঙ্গলবারে আর 24 তারিখে
24. I'm grateful to my lord. Thank you.
It is your lordship.
Malad, this is my application for passing of a preliminary decree, my lord, in a suit which is pending since the last 60 years. My lord, the preliminary,
65.
yes, my lord, the preliminary decree that I'm seeking for is in accordance with the lots which has been agreed to and divided amongst the three groups of co-owners, my lord. My lord, huge number of properties are involved. My lord, there are several properties, and my lord, the original plaintiff was, my lord, the executrix of the deceased, whose estate is having all these properties. Then, my lord, the executrix died. After the passing away of the executrix, to stop the suit from going unrepresented, my lord, this honorable court was pleased to appoint an administrator ad litem. The personnel of the administrator ad litem change from time to time. Presently, my lord, one Mr. Member of the bar, my lord, Mr. Shamul Kumar Mukherjee, is the administrator ad litem. My lord, the suit is in his name. He is the plaintiff. My lord, thereafter, after the filing of the suit, my lord, if your lordship kindly comes to the petition once.
Year 23.
This is GA 23, my lord.
The sub
Yes, my lord. There are affidavits. Affidavits have been complete. This is appearing as an adjourn motion.
A to F, 8, 10 and 11.
My lord, if your lordship kindly takes page 25 of the petition. My lord, because of the long pending litigation, 60 years is going on. My lord, from time to time, this honorable court, various honorable judges of this honorable court have been pleased to express their mind that the matter gets settled. My lord, at page 25, your lordship will kindly see, the order is dated 5th of July, 2018.
running page.
Yes, my lord, running page.
24. Justice Boshak's order.
Justice Orindam Sinha, my lord.
The page 24.
My lord, the petition.
Just
The petition, my lord.
petitionটা কোথায়?
Justice Sinha, my lord. I'll not trouble your lordship with the entire order.
Justice Majumdar's order.
My lord, I am referring to page 25, my lord. My lord, I will not trouble your lordship with the entire order. If your lordship kindly comes to page 26, the second last paragraph. Learned advocates are requested to use their good offices with their clients to see that a settlement is brought about. In the meantime, my lord, leave was given for supplementary affidavit. So, my lord, what I'm trying to impress upon my lord is that since 2018, this honorable court from time to time has been expressing their desire that the matter gets settled.
It's a 60 years old suit.
Yes, my lord, 60-year-old suit, and my lord, it's an
You are the plaintiff.
no, my lord. The plaintiff is the administrator ad litem. Yes,
You are representing?
I'm one of the defendants, my lord. I'm one of the defendants. There are three groups of co-owners. I appear on behalf of one group, my lord, and I'm one of them. 2H.
This is Mr. Ghosh's application.
Yes, it's my.
Yes, sought the relief.
Yes, my lord, I'll tell you.
Following relief.
Yes, and my lord, the next order, I'll come to the reliefs, my lord. I'll immediately take your lordship to the reliefs. My lord, page 27, if your lordship kindly comes. Again, the last order that I have shown to you, my lord, was of 2018. This is again as of
2022.
yes, again the same my lord, impression or expression, desire. It is submitted on behalf of Mr. Dotto, advocate, that this case has been pending since 1965 and the parties sought to settle their disputes. So, my lord, this has been the impression and this has been the wish of the honorable courts from time to time. Now, my lord, your lordship will kindly see the prayers that I'm seeking for. The prayers are at page, well, it's a summons, master summons. The master summons, your lordship will kindly take up.
Page 4.
Page 4 of the summons. Yes. Malad, prayer A is a preliminary decree we passed in terms of the admitted lots by the parties more particularly described in para 14 herein and in the annexure A to the affidavit in support of master summons. Prayer B is a commission be issued to an advocate with a direction upon him to partition the residential property 194 Vivekananda Road as indicated in lots A and B as agreed by the parties more particularly described in annexure A to the affidavit in support of summons, and thereafter final terms of settlement to be filed in court for final decree in the suit. My lord, as I have indicated to my lord, that I am seeking for this preliminary decree on the basis of the agreed lots that have been made. My lord, where the agreed lots have been done, my lord, all the three groups.
Your client and other defendants.
Yes, my lord. There are three groups, my lord. One group is that of my client, the defendant number 2's group. The other is that of defendant number 1, and third is defendant number 3. Your lordship will kindly see from the petition I have annexed. Yes, my lord, annexure A. Page 21, my lord. My lord, I had referred to the lots in that particular prayer, my lord. How the lots have been brought about.
Yes.
Annexure A, page 21. Only your lordship will kindly see this is the date of 5th of September 2022, as late as of 2022. Your lordship will kindly also take a note of the people present at the said meeting, my lord. Senior,
Presided by whom?
my lord, their names are there.
Presided by?
No, my lord, there was no.
There is no special officer or
No.
between the two parties.
Between the three parties, between the representatives and also the learned council.
Yes.
Your lordship has noted the names of my lord. My lord, the meeting, and may I just read out the first line. This meeting is held in presence of the learned advocates representing the three groups for amicable settlement of the properties under the suit. It has been agreed by the group of late Shambhunath Barik, represented by Ranjana Barik, and Nanda Barik, and the group of Sharajendranath Barik, since deceased, represented by Chandranath Barik, that lot A consisting of Darpana Cinema and its adjoining properties and some properties on Vivekananda Road, more specifically described in schedule, such and such, my lord, that these properties will go to one group and which has been allocated as Lot A. Then, my lord, next paragraph is Lot B, which is mentioned in Schedule B. And, my lord, the third paragraph talks about Lot C, which is mentioned in Schedule C. So, my lord, this allocation of the properties as per Lot A, Lot B, Lot C amongst the three groups have been all agreed by the representatives of the three groups in the presence of their learned and respective advocates. My lord, thereafter your lordship will kindly come to the last portion. That is the reason why, my lord, I have sought for prayer B. Beside the properties mentioned above, there is a residential house being 194 Vivekananda Road, Kolkata 6, which shall be divided between two groups, that is, between the heirs of late Shambhunath Barik and late Sharajendranath Barik, as shown in sketch countersigned by the representatives of three groups, annexed hereto and marked as Schedule B. My lord, this property, my lord, there has not been any physical partition of this. So a commissioner would be required for the purpose of having a physical partition with physical partition with regard to, my lord, the residential house.
Last paragraph, 194.
Yes, my lord, 194. This has been allotted to two groups, but, my lord, the physical
Schedule D.
no, my lord,
This
your lord,
is so as soon as sketch countersigned. Okay.
as marked as Schedule D. But, my lord, this property needs to be physically partitioned. And for that purpose, my lord, a commissioner needs to be appointed. And, my lord, the physical partition has to be done. And this property is to be divided into two parts, which will go to two lots, Lot B and Lot C.
Not Lot A and Lot B.
Oh, rather, I stand corrected, Lot A and Lot B. But the physical partition is yet to be made. That is the reason why, my lord, prayer B has been sought for. Now, my lord, they have filed affidavits in opposition to,
You are seeking at present which prayer?
my lord, for the moment, I would prayer A and B, my lord, both the prayers I would be seeking. And thereafter, my lord,
Yeah, even declaration as well as appointment.
yes, my lord, preliminary decree as well as appointment of a commissioner, or else, my lord, the terms of settlement would not be given effect to, because, my lord, the Vivekananda Road property has to be partitioned. Which part will go to Lot A and which part will go to Lot C? And B will have to be determined. It is only this much that is left. Rest, my lord, with regard to the rest of the properties, they have all been allocated and agreed to by the parties. Lot A, Lot B, Lot C. So, my lord, both these prayers would have to be, my lord, passed by your lordship for the purpose of
Be passed in terms of the settlement arrived between the parties.
obliged, my lord. As per the minutes that I've shown before, my lord. Lot A, Lot B, Lot C.
Save and accept the property, save and accept property of 194.
I wouldn't say, my lord, save and accept, because property of 194 is also included in two lots.
In this prayer A.
It is a combined property. It has to be divided into two halves to give a specific area that will go to one lot and the other specific to the other lot. So, my lord, for that, commissioner has to be appointed.
There is no specific allotment.
Yes, my lord.
Apportionment with regard to this.
Yes.
That is Lot C.
A lot A and
all are agreed.
I did you, that is last paragraph.
Agreement in the minutes.
my lord, if your lordship kindly sees in the petition itself, I've set out the lots. I've let out the lots. Page 12, your lordship will kindly see.
Page 12.
Yes. Lot A, my lord, your lordship sees. 84 Bidhan Sharani, 86 Bidhan Sharani, this, and this. And then, my lord, your lordship is coming.
Lot A.
Yes, my lord. Then Q, your lordship will kindly come. Q, page 13, the last item. So within Lot A is coming half of 194. So which half will come, my lord, has to be ascertained by way of appointment of a commissioner. E.
Is lot B also? That is
Yes,
P.
my P. Yes, P. Half. So it has to be determined, my lord. Both these. So till this determination is done,
Lot C is?
lot C doesn't have any portion of eviction on the property. Doesn't have.
Anyways, but declaration has to be made.
Yeah, yes, my lord. Because they have all agreed to it. Their shares have been allotted.
Paragraph 70. Is the
Paragraph-
sole exception.
Yes, my lord. That is the sole exception. And this is a unanimous decision, as I've shown to you, my lord, that there are other minutes also which are annexed to the affidavit in reply. My lord, that is the latest.
So during the pendency of this application, or
No. That is the last that I showed was the latest. There are meetings which are held much prior to that also. It's going on since long, my lord. As I've shown to my lord that
you have filed your reply, any other meetings you have annexed?
yes, I have. If your lord, there are two groups. The affidavit in opposition of defendant number 1, your lordship will kindly take.
There is an annex.
My lord, your lordship has been pleased to take up which reply, my lord? There are two replies of defendant number 1 group.
Approved by Chandranath Badik.
Yes,
on
my
this 23rd day.
My lord, there are two replies. There's one of Ranjana Badik.
This is against the opposition of Ranjana Badik.
Right. There, I'm open. My lord, if your lordship kindly comes to the annexures. Page 14 onwards, my lord. This is that of 1998. Here, my lord. Paragraph 2. And this lots have been made on the basis of civil engineers having been appointed, then valuation having been done, and accordingly they have done it. So, my lord, that would be evident from the minutes. My lord, paragraph 2. One Shamol Singho, a civil engineer connected with Singho Associate by letter dated such and such, has agreed to make necessary measurement in terms of the said order dated such and such, passed by the Honorable Appeal Court. Next, Mr. Chandranath Badik, that is the instant petitioner before my lord, representing the estate of Sharajendranath Badik, states that that already with regard to vacant area of land situated around Chaya Cinema and Dotmana Cinema have already been made by an approved surveyor valuer, and as such, at the moment, no new surveyor is required for the purpose of taking measurement of the vacant piece of land. So, my lord, from this, it goes to show that valuers have already been appointed. And my lord, I'll show from the other minutes that there has also been occasion of revaluing the properties. So, I understand that there have been two occasions when valuation of all the properties were made. And it is as per the valuation that the lots have been agreed to. Now, my lord, your lordship will...
Considering the valuation.
Yes, my lord. Your lordship will kindly come to page 15, the next. My lord, this is of 2004. Yes, a long time ago.
Regarding your petition, the meetings were dated which?
No, that is the latest one, 22.
Your petition?
Yes.
These were all earlier.
So this is also in my reply. What I'm trying to impress upon your lordship is that the system of lots and allocating the properties amongst the parties in 3 lots have been accepted by all the parties since long. And it is upon acceptance of this, pursuant to orders passed by this...
Purpose of reference of the earlier meetings.
Yes, my lord. And that valuers have been appointed and properties have been valued and revalued. My lord, there is a point that has been raised on behalf of Mr. Mitra's client, is that the property again requires to be valued, without which the allotments cannot be made. To that, my lord, my submission is the properties have been valued and revalued, and it is on the... My lord, it would appear from the next page, page 15, your lordship will kindly see.
Page 15.
Yes, my lord. This is of 23rd of February 2004. Well, maybe that it is for long, But then,
Valuation may
whatever,
increase with regard to all lots.
yes, it will be same. At that point of time, if my lot was valued at 5 lakhs,
Yes.
the other lot was equally made. So if my lot is increasing, their lot will also increase. So if it keeps on, revaluation and valuation keeps on going, for the last 60 years, it has been extended. It will go on for the next 60 years then. Then your lot should kindly come,
Valuation is 2004.
last valuation is 2004.
97.
Oh, 97.
97.
97. 2004, my lord, there's a mention.
Anyway, meeting.
Yes, your lordship will kindly see.
On the basis of 1997 valuation report, meeting was held in 2004.
2004, and then my lord, previous 1998, also 1998, page 14. Page 14 also. Annexure A.
Yes.
1998, then 2004. Then your lordship will kindly see several meetings have been held. Then the last one that I've annexed is of 5th of September 2022. That is the one that I've already shown to your lordship.
Meeting, when the last meeting was held, it was within the knowledge of the parties regarding valuation. Was it not within the knowledge of
Yes, all the parties, my lord, your lordship will kindly see the.
Is there any mention about the valuation report in the meeting?
Yes, that is exactly what I was about to show to your lordship. If your lordship kindly comes to page 16 once. Page 16, more towards the beginning, my lord. The properties standing in the name of the person to be allotted.
Which page?
Page 16, the affidavit in reply to the opposition of Ranjana Barik, the one that your lordship was seeing.
Page 16.
The properties standing in the name of the person to be allotted to the group of the same party, then the total properties to be again revalued by a panel valuer suggested by Mr. Chanchal Dotto, whose valuation will be accepted as fair valuation. So, my lord. Yes.
Whether the last meeting, yes.
No, I'm not interrupting, my lord. Let my learned friend conclude, my lord. May I respond on, my lord, on some other day? Feel court, my lord, a matter is complete. Any other day convenient to the court, my lord? I'll be come.
Valuation. Board meeting. This is what, 2000?
This is 2004.
Yes.
First is
Now,
98.
Yes, valuation report was there before the parties in 2004. But in the latest meeting, it was unanimously agreed with by the parties. Was there any whisper about valuation report?
With the deepest of respect to my lord, the valuation report, the whisper with regard to valuation report would not.
Consider the valuation report.
My lord, your lordship will kindly see. In 2004 itself, the lots were made. So the lots were made, my lord, again, my lord, with respect.
Yes, yes,
If the
2004
lots were made in 2004, I put a question to myself, would it again be necessary to revalue the lots? Because the lots were already by that time valued. The lots were allocated and agreed in 2000, way back, my lord, your lordship will kindly see way back in 2004. And that when the lots were agreed to, and your lordship will kindly see who are the parties, then this will be a never-ending process.
2004, the same parties were there?
Yes, yes, oh, yes, yes, yes. No. The representatives are all same.
Okay.
The representatives are all same. Your lordship will kindly see the names.
Yes, if one lot enhances, one valuation increases with regard to one lot corresponding increase.
Everything will increase, and if it is decreasing everything, my lord, with respect, then it will be a never-ending process. It will never end.
See, to avoid, to remove this technicalities, there is the mention of this law. That is why I'm asking.
My lord, the lot is mentioned in 2004.
Regarding
2004, your lordship kindly comes.
agreed by the parties upon consideration of the valuation report, because you see, after all the parties have agreed.
Yes, my lord. They have. And your lordship will kindly see what is written here at page 15. After long discussion, it was decided as follows. After long discussion, so it's not that it's happening in a day's time. It's happening over years together. And my lord, your lordship will also kindly see the representatives. All the three groups are represented. After long discussion, it was decided that follows, then the following properties to be allotted in the groups, my lord, they have mentioned. And this is the same lot. It's not that there has been any variation with regard to the lots. So, my lord, with deepest of respect, again, the mention of valuation maybe was not necessary. And the same lot, my lord, continued as late as on September 2022.
5/9/2022.
Yes, my lord. And there has not been any, my lord, mention of any valuation that they are dissatisfied with the valuation.
Meet the objection of the defendant, Mr. Mitro.
Yes, they are saying revaluation once again. But they are saying revaluation once again. My lord,
Taking this stand in these arguments or in their opposition.
no, in the opposition. In the opposition, they have taken basically 2 points. One point is that this is an administrative suit, as a result of which I cannot claim preliminary decree because preliminary decree are passed in partition suits. That's number one. And secondly, my lord, their objection is that they are also wanting to put an end to the dispute, provided that all the properties are again revalued. I put a question to myself. Once you have agreed to the allotment since such a long time, the same allotment is being agreed to again, then where is the question of revaluation? I'm putting the question to myself. And my lord, with regard to the suit being administrative suit, my lord, there are two things. First of all, this application is pursuant to, my lord, the desires of this honorable court having been expressed from time to time that you settle.
No, that is true. But regarding the power of the court.
I will come to that. I'll come to that, my lord. I'll come to that. My lord, from time to time, this honorable court has passed, and parties by their conduct have accepted the fact that they would want to get the properties divided amongst themselves in 3 lots by their conduct. And my lord, I'll rely on one judgment. Your lordship will kindly allow me to find out the best print. This is a good print, but then your lordship will kindly excuse the pencil markings, my lord. The other prints have come out very hazy. Other prints have come out very hazy. Lordship will kindly. My lord, it's reported in 2018, volume 3, Maharashtra Law Journal. My lord, it's also on SCC online. My lord, I am relying on the head note that if your lordship kindly.
21 you are relying.
Paragraph 22 more so. 21 and 22, more so on 22.
Page number.
If I may read out. An administration suit, as noted earlier, is essentially one where reliefs claimed relate to seeking administration of the estate of a deceased under orders of the court. The quintessential aspect which qualifies any suit, Gauri Gaikwad, for being called an administrative suit is that the reliefs claimed involve the administration of the estate of the deceased. A suit for a legacy or for a share of a residue bequeathed by a testator or for a distributive share of the property of an intestate can only be by a legal heir. In such a suit, this was with regard to limitation, my lord. So Article 106 will be applicable. But while an administration suit by a creditor for recovery of his debt, there is no specific period provided, and therefore the residuary Article 113 will be applicable. So this was with regard to that particular matter which involved limitation. What I'm trying to rely upon is in paragraph 22. Only one line that I rely upon, my lord, more towards the middle, merely because plaintiff has used. May I have my lord, this is the line that I'm relying upon. Merely because plaintiff has used the nomenclature administrative suit, the suit does not become one only for administration, because other reliefs may also have been sought, like to enforce a right to share in a joint family property. So, my lord, my humble prayer here would be that these properties are all joint family properties. They have agreed that these properties
For residential as well as commercial purpose.
mostly for residential, mostly
Very few for commercial.
I don't know whether there would be commercial. There are commercial properties also. So, my lord, but then the parties have agreed that they're the properties of the joint estate, that is the joint family property. And, my lord, the parties by their conduct have also, in the course of time, wanted the properties to be divided amongst themselves. And so, my lord, this
That change of nomenclature does not change the nature of the.
that is my submission before my lord.
That is one aspect of the matter. The other aspect is evaluation is necessary.
That is what they say. And for me, my humble submission would be, it is upon consideration of the valuation, the parties sat together, and after long discussion, they have, my lord, allotted themselves the shares. And it is the same allotment that we are wanting in 2022 and also today. I am referring in my prayer, your lordship has seen, I referred to the allotment that has been made in the meeting itself. So, my lord, I'm not changing any allotment. There has not been any change or shift in the properties. So, whatever has been the valuation, then if it has increased for everyone. If it has decreased, it has decreased for everyone. Again, revaluation, again, resettlement, again, rechange. It will continue for years together. And, my lord, there's one admission that I would like to rely upon, my lord, both in case of both the defendants. What they are wanting to also, defendant number 3, the other group, they, my lord, are wanting, if your lordship kindly comes to the affidavit in opposition of Sharbojit Barik. Affidavit in opposition of Sharbojit Barik. Defendant number 3. Sharbojit Barik, there is another affidavit. Defendant number 3. The thin one. Thin one. Yeah, that's the line.
Yes.
Paragraph 9, your lordship will kindly come. I further submit that to put an end of the long-standing dispute about 60 years, order may be passed on this application and such and such. So, my lord, everyone is wanting that there should be an end. And this is the only way how an end can come.
One of the defendants.
One of the defendant group. Whole group. I am other whole group. Is the only contesting group for the moment. I do not know. I put a question to my.
He was a party to the.
Yes, all throughout, agreed everything. Again, to my lord, to pull it longer for the next 60 years, this again a new point is being brought.
Irrespective of valuation, okay, if a decree can be passed, the court has to pass a decree.
I'm obliged, my lord. My lord, my main point before your lordship would be that the lots are the same. There's no change in the lots. So if you have agreed to
the admission should not be acted.
I'm deeply obliged. I'm wanting a consequential prayer. Parties have agreed, the rights have to be determined by way of a preliminary decree, and in order to give full effect to the terms of settlement, the commissioner has to be appointed. I've shown, my lord, half of the residential to one lot, other half to the other lot. So in order to give effect to that, my lord, a commissioner has to be appointed.
All terms of settlement not filed in court.
No. That has not been, that could not be done till the commissioner is appointed and the halves are determined. I have made that prayer. If your lordship kindly sees the master summons.
An understanding. That is one type of that meeting. The settlement meeting is one type of understanding. A memorandum of understanding, it may say. Where stamp duty is not
paid. Not paid. My lordship,
If it is a settlement, then stamp duty has to be paid.
yes, it has to be. My lord, prayer B, your lordship, sees the last portion. Master summons. B.
Yes.
The last portion. The first portion is with regard to the appointment of a commissioner. Then, my lord, final terms of settlement to be filed in court for final decree in the suit. Thereafter, until and unless these preliminary steps are taken, my lord, the final decree cannot be passed.
A
And B, both,
Yeah.
to give effect to the terms or the agreement. Now, my lord, they're wanting to change again revaluation as per the lots. Already one property has been sold by them, which had fallen in their accepted lot. Having considered,
It's sold, is it a subject matter of?
yes, this is part of the lots. So they've accepted the lot system. Having had accepted, now they're turning around. The Darjeeling property,
Sold the lot on what basis? Just
on the basis that this is a personal property. On the basis that this is a personal property,
As lots has been divided amicably, my lord, that's why, my
after
lord.
2004.
when they have sold the property, they will be able to say.
No,
After
cannot.
2004? Yes, my lord, after 2004.
They have accepted it.
Whereas the father of the present heirs of that particular lot in the affidavit, in the examination deposition before this honorable court in the suit said, no, all these properties are joint family properties. But they have already sold. I'll come to that after they give their reply. After Mr. Mitra makes his submission.
So let me.
Lord, I have, my lord, I have one point to say. Lord, I am appearing, my lord, respondent number 3A, 3A to 3F. My lord, your lordship kindly come to the affidavit of my lord Sarvajit Bari.
The one your lordship was seeing right now.
Just now, your lordship has seen.
Yes.
Your lordship.
Repeat of service. What would you call it? Your
Yes,
representative.
yes. Your lordship kindly come to page 6.
It's 6.
Last paragraph. It is further decided by the three branches. We will convey the meeting shortly to finalize the pending terms of settlement. Well, actually, terms of settlement has agreed between the parties and lots have been divided accordingly. And put to an end the litigation forever. In case the terms of settlement could not finalize, the suitable direction shall be obtained from the concerned court to settle the pending dispute. Your lordship, you will see, my lord, everyone has agreed to the lots. And my lord, end of this litigation, my lord, they have agreed to this term. To the your lordship, kindly pass an order.
So, my lord, your lordship will kindly say out of the 3 groups, 2 groups are wanting that this be executed, put to
I
execution.
am opposing the point. Kindly see page 21 of the petition.
Of the petition.
Petition. Page 21 of the minutes dated 5th September 2022. The settlement has not been finalized. It will be evident from this minutes, my lord. Kindly see page 21, minutes dated 5/9/2022. The top shows that minutes. Last page, kindly come to page 22. Last line. Parties will sit further to decide of the vacant portion of the backside of Chaya Cinema on 22nd September 22. Thereafter, no sitting was held between the parties. The Chaya Cinema property was there. That means property has not been finalized. Settlement has not been finalized. Kindly see this line. Parties will sit to decide the vacant portion on the backside of Chaya Cinema on 22nd September 2022.
Chaya Cinema already allotted.
Cinema falls under which law?
Yes, it has already been
Lot B.
allotted. And
Law.
yes,
Lot B.
Lot B.
But valuation, vacant portion
Lot
not in
B.
valuation.
That has been included, and that has also been measured.
Second land has been not been valued.
Again, it has been measured after this.
Not valued.
After this meeting, it has been measured.
Not has been disclosed.
Yes,
Have you annexed that?
I have not, but I can.
Not
And that I understand they have, my learned friends' clients have got it done.
Not, I do not know.
Let him take
instruction.
proper
But
instructions.
if their property, they have assessed.
To adjourn for Mr. Mitra to make.
Yes, in the meantime,
You want to file a supplementary.
no,
affidavit?
they should file. They have got it measured.
No,
it
you
was made
your
that.
client was also
We don't
present
know.
during
Yes.
the.
Yes, my
You
client was
filed.
also present during the measurement.
So you have
But
also-
it is at their instance. Your lordship-
If you have measurement, then
You file it. I don't know. Why- You have made-
Everyone was present.
One. It is not in the record, this averment. You can include in your supplementary affidavit, give copies to others. If you have any document with regard to that, you.
I wouldn't have any document,
But
my
you
lord.
can
As per
affirm it.
instruction, I can affirm it that it has been done.
Because you see, they are relying upon this.
Yes,
So you have to, you state that yes, if they.
I will do that. I will do that if your lordship so pleases.
Right,
But
sir.
it was at their instance that the measurement was done, and
You and
they would have the minutes, if at all records of the measurements.
Measurement is done in the presence of the party.
Yes. It was done in the presence of the parties. I can affirm an affidavit. I can affirm my affidavit to that extent. I'm making this submission on instructions right now.
The petitioner, defendant,
2H.
H.
Yes.
It's. But however, he intends to file a. Thus, Mr. Ghosh is granted liberty, file the supplementary affidavit and conclude his submission on the next date fixed. If this.
If it can be sometimes next week, subject to your lordship's convenience, my lord. I'll leave it to you.
Keeping it next week, let this matter appear on, but you can file your affidavit also.
Then I have to file reply, my lord. Kindly take it
March,
to
July.
July, first week of July.
Okay, give him advance copy.
I will.
First week of July, my lord.
Sometimes before, my lord. It's pending since 60 years. 60 years, my lord. Your lordship will kindly consider that.
Next week.
From third to
Yes. No, Mr. Mitru will be here on
Yes,
24th.
yes.
No, I'm keeping it on 24th.
24. For
further hearing of this matter.
Deeply obliged, my lord.
Well, I believe within 1 or 2 days.
It should be.
Concluded.
It should be. I'm
Do you
deeply
have any
obliged.
documents regarding that
I
measurement? You
will
also
try. I
allocate.
will try. Thank you. And I'm obliged.
Get.
Item 17.
I appear for the respondent. In terms of the last order, my lord, I have filed my opposition.
Is on text, my lord.
Okay, not today.
But a short password, my lord.
No.
Or may I file my affidavit in opposition, my lord? They've not filed any rejoinder, so I take it that, my lord.
For the.
My lord, I appear for the petitioner. I appear for the petitioner, my lord, in its supplementary opposition, my lord, respondent has disclosed documents which it has not dealt with on merits. Now they have disclosed the orders of court by which they want to argue that the company is under liquidation and a liquidator has been appointed. Now, my lord, the company has never been, there's been no order made for liquidation and liquidator has never been appointed. The lordship will kindly give directions to the liquidator to remain present when the matter is taken up, so this can be clarified. Otherwise, my lord, my whole proceeding becomes bad because his contention is that I am not entitled to represent the company.
Give your reply. On the next day, I shall pass necessary directions. Learned advocates for the parties are present. Let affidavit in opposition filed by the respondent be kept in the record. Let reply be filed.
By Monday, matter be taken on.
By Monday, my lord, I'll file the reply.
3rd June 2025. Let this matter appear on 24/6/2025.
Grateful. But may it be on 25th, because 23rd, I don't know when they're going to serve me. Or the next day, the next chamber.
26th.
Lord, I'll give it on Monday then, my lord.
Great.
By evening. It will appear on 26th.
Grateful, man. Deeply.
Grateful, my lord.
It's my mallet application. GA mallet, G number.
Your lordship, I am for the plaintiff respondent, your lordship. I want to pray some time to file my affidavit, your lordship. Within Tuesday, I will be filing my affidavit, your lordship.
On 10th of June, mallet, there was already a direction to file the opposition mallet, not extension.
Within 16th, it was to be filed.
It was to be filed mallet within 16. No.
Within 16th of June.
Yes, mallet.
Yes, your lordship.
10th of June.
Parties are present. Learned advocate for the plaintiff opposite party prays for time. File affidavit in opposition to GA 4 of 2025. Such prayer is allowed. Let affidavit in opposition be filed by 26 6 2025. Reply if any by 30th June 2025. Let this matter appear on 1/7/2025.
Your Lordship, I want to just make one submission, one more submission, Your Lordship. If Your Lordship kindly allow me to amend the application, amend the cost title of the plaintiff, Your Lordship.
There's no
Because the name of the plaintiff and the defendant have already been changed, and so the amendment application has to be done.
there is no application to that effect.
Only name is.
I want to get Your Lordship's leave to file the application, Your Lordship.
File it. So no
leave is required for that.
File it in the meantime.
It's this application is for extension of time allowed to file the written statement.
Anyway.
We'll come back.
Obliged, Your Lordship. Obliged, Your Lordship.
Let this direction be peremptory because he's taking an extension.
He did not suffer anything. So there is no interim order. I mean.
Come back, my
Bill 25, item 25.
Item 25.
Obliged, Your Lordship.
Based on 1st July.
Okay, let me sit in court.
Fine.
Thereafter I shall take it.
May I crave your lordship's leave to mention one matter, my lord. There is a pending suit bearing suit number 434 of 1992. Well, it's not appearing in the list. Not appearing in the list. But in this matter, the previous lawyer who was engaged for plaintiff number 1A, 1B, and 1C has expired.
Right.
My lord, I have been inducted as a new lawyer. I just craving your lordship's leave to file the wakalat. My
Yes,
lord,
yes,
in the
leave
department.
granted.
So may I have lordship's leave? Lordship, this matter was supposed to be appearing on 9th of June after the jurisdiction changed, after the reopening, for confirmation of a report filed with the chairman.
Yes.
Ex-Chief Justice Jyotirmay Bhattacharya. He had conducted an election of the Dakhineshwar Kali temple. So that was conducted and the report
which
now
year?
has been confirmed.
No, which year suit? Suit of which?
Suit is prior to 2014, 1872. Lordship's jurisdiction.
So let it appear as to be mentioned.
To be mentioned, and Lordship, the report has been filed before the registrar. So the registrar has to produce the report.
Let it appear, thereafter I shall pass direction.
Tomorrow?
Tomorrow or Monday? Yes, tomorrow.
Tomorrow. Obliged, Lordship. Order to the pore niye.
Any other mentioning? To be mentioned, item number 19.
I appear for the plaintiff in this matter, my lord. This
Yes.
matter was listed yesterday, my lord, when your lordship made this matter returnable on 30th of June, my lord.
Yes.
I do not know why this. Oh, probably the report has come, my lord.
Okay. So probably thereafter this report was placed.
Lordship.
Order ta kothay? June, right? 18th June order. 15th. অর্ডারটা সার্ভার হয়নি এখনো। আচ্ছা 18 জুনের অর্ডারটা আসুক, হ্যাঁ, তাও এটা নট টুডে। ওকে, লেট ইট বি নট টুডে।
Item number 20.
I appear for the plaintiff. This has come up at our instance. My lord, this matter is ready for final arguments. The defendant, lordship, on the last occasion, there was an application which was filed by which one document was impounded. Lordship, there was a direction. Lordship, may kindly record that.
The last order.
Lordship. Order dated 30 April.
Yes, 30th April, this order was passed by Justice Majumdar.
Lordship. But this was in an application.
Yes. Yes, by order dated 30th April, the matter was sent to the collector.
The Exhibit A only.
Yes.
Exhibit A was sent to the collector, and for Lordship, we kindly record that we shall not be relying on Exhibit A during our arguments. My lord, we shall not be placing Exhibit A. Because the contents of Exhibit A, which
Question is, I have to see the report also because the court has impounded the document.
is not.
Okay, and has sent to collector. Now the collector reports must be perused thereafter. The court shall.
Then my lord kindly directs the registrar
Yes,
lordship to take steps, my lord.
Learned advocate for the, you are for the defendant.
The plaintiff.
Plaintiff is present.
The defendant, I can see her online, but I do not know.
In terms of order dated 30th April 2025, the document which was marked Exhibit A was impounded and sent to the collector for doing the needful in terms of the Indian Stamp Act 1899. Stop. Thereafter, the report of the collector is not in the record. Stop. Learned Register Original site is requested to submit a report as to the decision taken by the collector on the document which was impounded. Let a copy of this order along with order dated 30th April 2025 be sent to the Registrar Original site.
Lordship keeps it returnable after 2 weeks, madam.
Let this matter appear on 3/7/2025.
Lordship. Inshallah. 3rd July, madam. I'm grateful.
For orders, item number 21.
I am for the applicant.
But I am appearing online.
Yes, this is the case where report, I think it was directed to take a inspection and submit as to whether the heirs were substituted or not.
My lord.
Let me see the last order. Yes, department report দিয়েছে এটা? Any report submitted? Yes, record an order. In terms of the order dated 23rd May, আচ্ছা তার আগে করে দেবেন. Learned advocates for the parties are present. In terms of order dated 23rd May 2025, the department was directed to submit a report as to whether the death of Amar Kumar Mullik, the defendant number 5, is recorded, and whether his son Tapun Mullik and his daughter Nilima Mullik was substituted.
Nilima Das Mullik, my lord.
Nilima?
Nilima Das.
Anyway, stop. However, no report is received in terms of the said order. Let a reminder be sent and let a report be submitted on or before 2nd July 2025. Let this matter appear on 4/7/2025. Let a copy of this order along with the order dated 23rd May 2025 be sent for necessary steps.
Obliged, my lord.
Item number 22.
My lord, I appear for most of the defendants in this
Yes.
matter.
My lord, I appear on behalf of the petitioner, my lord. On the last occasion, my lord recollects that my lord had completed the hearing
Yes,
of this
yes, yes.
particular application, my
Yes.
lord. GA 26, my lord.
GA 26.
Yes, my lord. My lord, this is with regard to the sale of certain properties described in paragraph 15 of the application, my lord. Our submissions, my lord, were almost complete, my lord.
Anyway, so the petition is allowed. Let there be an order in terms of prayer B and C of the notice of motion dated 12th day of March 2024. 29/7/2025 for report of joint receivers and further orders.
Fair enough, my lord.
Only one intelligence, my lord. On the last day, the order passed.
Yes.
My lord produces the order. My lord, the attendance of the advocates. The name of the receiver has been inadvertently mentioned to
Name of?
name of one of the joint receivers have
Yes.
been, my lord, inadvertently mentioned to have been appearing for the plaintiff. My lord, such will create a confusion in future courts. My lord, let that be amended.
That is
আগের দিনের অর্ডারটা দেখি এটা
Mr. Shubhankar Chakravarti's name has inadvertently been incorporated in the names of the advocates representing the plaintiff.
But he's the administrator.
Yes, my lord. He is the receiver, one of the joint receivers, my lord.
Yes.
My lord, may I just show the order, my lord?
Yes.
My lord, right at the top, my lord, will find under the names of the advocates appearing on behalf of the plaintiff, my lord. My lord, his name has to be omitted from the arraignment of the advocates, my
Okay,
lord.
mentioned the records have not come. Let it come on some other. Let it be
My
considered.
lord,
on
may I
some other-
indicate this particular correction in that
So,
order?
that is
Mr. Shubhankar Chakravarti's name has to be omitted, my lord.
In the category of for advocates
the
appearing for the plaintiff, my lord,
plaintiff, my lord.
third name will go for the receiver.
That has to come under the heading of the receivers, my lord, the joint receivers.
it is further pointed out
Agad in order.
by the learned advocates. You are appearing for
My lord, I am for the petitioner, my lord.
petitioner
Yes.
that on in the order dated June 12, 2025, the name of the administrator,
My lord, joint receiver, my lord.
joint receiver, Mr. Shubhankar Chakraborty, is wrongly recorded as advocate for the plaintiff. Let the mistake be rectified.
I'm extremely grateful, my lord.
My lord, another thing is that the name for the counsels appearing as for the defendant. However, my lord, Miss Madhurima Haldar and Mr. Sunil Kumar Singhani are only representing about 20 to 25 defendants. Your officers have been given a list of all the defendants that I'm appearing for. But however, in the order it records for the defendant. However, I'm not representing all the defendants, my lord. So I have given a list for the same. May it also be rectified, my lord.
Okay, let the names of the learned advocates shown to be representing the defendant in order dated June 12, 2025 be rectified and corrected as defendant number dash 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 dash.
29 July.
Order to দেওয়া আছে matter to appear মানে GA 26 matter to appear to দিয়ে দেওয়া
সেটা রিপোর্ট দেবে ওটা ওরা দেবে
না, না।
2 weeks টাইম আছে
matter 29/7 for report of joint receivers. 29th of July. GA
Grateful, my lord.
26.
I'm grateful, my lord.
যা আছে এর মধ্যেই এটা সার্ভার হবে যখন এটা সার্ভারের সাথে ওই অর্ডারটা ঢুকিয়ে দিতে হবে। হ্যাঁ হ্যাঁ তারপর এটার সাথে ওটা একসাথে দিয়ে দিতে হবে। Yes, next.
Item number 23.
My lordship, I appear for the plaintiff.
I for the defendant, my lord.
Yes, this is GA4.
Yes.
Yes, this petition of the plaintiff should be allowed. Let there be an order in terms of prayer A of the master summons dated 30th day of July 2024.
I'm grateful. But one more prayer.
Yes.
Insofar as the suit is concerned, but I am told one of the records in the judge's brief which was filed earlier, that has been misplaced from
Can
the
you
record.
take steps?
But I'll have to take steps.
Let this be rectified. Let this be done. Okay.
Yes, my lord, I'll give inspection of these documents to my learned friend, and thereafter, my lord, lordship will grant me leave to file an additional judge's brief along with reconstruction of the previous judge's brief.
Okay, you mention it afterwards.
But
No, because
if your lordship kindly grants me that order and keeps the matter, my lord, after 2 weeks, my lord, so that in the meantime.
My lord, I have got a prayer, my lord. Earlier, there was an advocate, only he expired suddenly, my lord. That's why, my lord, the documents which my learned friend disclosed there, my lord. In fact, I do not know whether any inspection has been given or it has been taken. I do not know, my lord.
Has been
That
done.
inspection is, further inspection is required, my lord.
Record an order. Let this matter appear on
Inspection for new document.
A new is fine.
10th July 2025. Necessary discovery and inspection be made in the meantime with regard to the new documents.
Necessary inspection, well, I've already disclosed the document. Necessary inspection may be
Necessary
taken.
inspection to the new documents may be made in the meantime.
My lord, and lordship
But
will
also, my discovery, because I am the defendant, I also then supposed to, once
Then
he
you
has,
have to write to them.
I will write,
Everything is done.
I will write to
Previously,
them,
it
my
is
lord.
only
They are now constructing, my lord, new judge's brief of documents. Then
Let-
that,
it's the additional judge's
You
brief.
take an inspection of these documents. With regard to earlier documents, if you want to inspect or do anything, you write to them.
But-
They will
My lord,
do the needful.
yes, my lord. Only one thing, my lord, lordship may record in a lordship's order that the initial judge's brief of document may be reconstructed, and lordship will grant me leave to file the additional judge's brief within the specified time.
This matter appear on the next day. I shall
Yes.
pass that order.
Very good. Very good. May the
Or you can come to
reconstruction
the
be,
necessary application.
my lord, may the reconstruction be done in the meantime, insofar as the previous judge's brief is concerned.
So for that, you better make an application.
Or reconstruction, lordship may.
Why reconstruction is
Because
necessary?
my lord, the records from the judge's brief is not there in your lordship's records. That's what we are told.
let the matter appear, he will come.
But
with
the written statement has already been reconstructed. That was also missing.
On the next day, after you take steps and after these inspections and everything is over, I shall pass necessary orders regarding.
And then may I make one request, my lord? If, my lord, I'll give inspection of the documents. The previous trend, the conduct of the whoever was appearing was that despite repeated notices, he was not taking inspection. My lord, even lordship will
Anyway,
fix
I'm
the
granting
time.
one more opportunity. Let it be done.
Lordship will grant them one opportunity to take inspection. I'll write a letter to them to take inspection of the new
Yes.
documents.
So I've kept this matter on this thing.
10th July.
10th of July. You're getting sufficient time.
My lord. Yes. Grateful, my lord.
No motions, item number 24.
My lord, I appear for the plaintiff respondent here. My filing clerk will extend the affidavit in opposition.
Yes. Mr. Mitru, it is your application.
আমাদের রিপ্লাই
Yes.
Now, my lord, if your lordship is pleased to look into the cost title, my lord, lordship will find that this suit was filed, my lord, in the year 2009. Goes against me.
Yes.
But it was filed again in, my lord, in the year 2009. It is a suit for partition, my lord, which is important. It is a suit for partition. Everybody is plaintiff, everybody is defendant. Now, my lord, in that suit, on 27th April 2009, my lord, an interim order was passed. Lord, if your lordship is pleased to come to page 19.
Page?
19.
19.
First annex.
Yes.
My lord, order passed by Justice Patheria. Kindly look into the first paragraph, my lord. In a suit for partition and administration of movable properties mentioned in Schedule A and lying at premises mentioned in paragraph 4 of the plain, this interim application has been filed for appointment of receiver to make inventory of the movable assets. Then, my lord, kindly come to, my lord, that was allowed, my lord. Kindly come to page 21. My lord, about 5 lines from the top at page 21. Therefore, to protect the interest of all the parties as the movables were not the subject matter of such and such, Mr. So-and-so advocate and so-and-so advocate are appointed joint receivers to make inventory of the movables lying at premises number such and such and at Shimultala and also at BT Road, etc. This was the order, my lord, passed in 2009.
Yes.
Now, my lord, thereafter, no further step was taken by the plaintiff in the suit. No step.
Yes.
Now, in 2016, my predecessor, the original defendant number 1, had filed an application for dismissal of the suit on the ground that, my lord, no writ of summons was served.
Yes.
Now, my lord, in that, an order was passed. And, my lord, when I made, my predecessor had made.
Just a minute. In this matter, is there any scope for any interim order?
No, it's after affidavit.
Oh, affidavits are complete?
Yes.
Okay, let me proceed.
It's possibly wrongly appearing as well as
Yes, yes,
demotion,
yes.
but
That's why I asked. There is any
your
scope.
lordship wants, my lord, I can come back on some other day to regularize, my lord, if your lordship wants. Otherwise, my lord.
Let you be both, as both parties are present, let you proceed.
Yes, of course.
Defendant,
It should appear as adjourned motion, as my senior friend said, my lord. It is wrongly appearing under the new motion. Anyway,
Anyways, because both parties are present, I'm just taking it.
Yes, very well. I have no difficulty, man.
Yes.
Now, my lord, when my client, the predecessor of my client, the original defendant number 1 had made the application for dismissal of the suit, the plaintiff had made an application, a subsequent application, praying for, my lord, extension of time to, my lord, or issuance of writ of summons and lodging it with the. Now,
This
both
application is yet to be decided, the plaintiff's application.
No.
Or it was decided.
Both the applications were decided, my lord. Kindly come to page 22.
Page 22.
Yes.
Yes.
Order dated 28 February 2017. GA number 2511 of 2016 is an application taken out by the defendant number 1 in the suit for dismissing the suit on the ground of non-service of writ of summons, even 8 years after the institution of the suit. GA number 3685 of 2016 is an application made by the plaintiffs number 1 to 6 and 8B, praying for extension of the returnable date of the writ of summons and for appropriate direction for issuance of the writ of summons. I have heard learned counsel for the parties. Then, my lord, kindly come to the third paragraph in the next page. Or, my lord, the first paragraph, my lord, the advocate rightly points out that there is no prayer for, in the application taken out by the said plaintiffs for extension of time to lodge the writ of summons. Hence, merely extending the returnable date of the writ of summons will take the plaintiff nowhere.
No, yes, which page? 23.
Page 23 at the top.
Yes.
The the advocate rightly points out that there is no prayer in the application taken out by the said plaintiffs for extension of time to lodge the writ of summons. Hence, merely extending the returnable date of the writ of summons will take the plaintiffs nowhere. He is absolutely correct. However, I grant leave to the petitioners in GA numbers 3685, that is the plaintiffs, to add a prayer being prayer AA for extension of time to lodge the writ of summons. The prayer so added is to be countersigned by the assistant registrar. Then kindly omit the next paragraph. Kindly come to the third paragraph. Accordingly, there will be an order in terms of prayer A, B, and C of the petition subject to the applicant plaintiffs paying cost assessed at such and such cost is to be paid within a fortnight, etc. Now, my lord, this was the order passed, and the next paragraph, time to lodge the writ of summons is extended by 4 weeks from date, subject, however, to payment of cost as aforesaid. In view of the aforesaid, no order is passed in my application.
How many years delay there was? How many years delay? Yes?
9
years. 9
9
years.
years.
9 years delay. Yes.
9 or 8 years, whatever it is. No. Suit of 2009, order was passed in 2017.
Yes.
Now, my lord, the original defendant number 1 belatedly had affirmed and written statement also. But, my lord, I really do not know the then advocate on record, my lord, it was not filed. I have a, my lord, copy of that written statement, but, my lord, the record shows that, my lord, it was not filed.
Yes.
Now, after that, my lord, the COVID pandemic, my lord, intervened. The original defendant number 1, my lord, she died on 10th of April 2023. Now, my lord, it was intimated to them. And then, my lord, they had taken out an application. The plaintiff had taken out an application. My lord, kindly come to page 24. Order of 1st May 2024. In terms of the order dated 19th March 24, this court observed that the defendant number 1 had expired long ago, but it is a partition suit for which right to sue survives. It was observed that the plaintiff did not file any substitution application. Liberty was given to the defendant number 1, being on the record of the representative of the deceased defendant number 1. Subsequently, the instant application has been filed on 21st March 24, praying for substitution. There was also prayer for condonation of delay.
Filed by the plaintiff, the substitution application.
Yes. Learned counsel for the defendant number 1 submitted that liberty was given earlier to defendant number 1. However, he is not standing in the way of, in the interest of expeditious disposal of the suit. Accordingly, prayer was made, my lord, for substitution. Unfortunately, my lord, even after the substitution, my lord, which is required to be done is, my lord, service of the amended plain, that was never done. The amended, my specific case is, my lord, that the amended
The summons of the
yes. And the amended plaint has
informal service was effected. Informal service of the amended
no,
plaint.
the plaint, no. That was not done. Now, my lord, I have pleaded that. That, my lord, the kindly come to yes, paragraph 15, page 12. I say that in spite of such order of substitution being passed, the plaintiff.
Paragraph 15
my lord,
of your petition.
of my application, my lord, page 12.
Page 12. Yes.
I say that in spite of such order of substitution being passed, the plaintiff did not intimate the substituted defendant as to on what date such substitution has been carried out by the plaintiffs. The amended plaint was also not served upon the substituted heirs, being the applicants herein. As such, effectively, the time to file the written statement by the substituted heirs have not commenced as yet. Under such circumstances, the matter appeared before your lordship, my lord, on 17th April 2025, wherein leave was granted by this honorable court to take out an application seeking leave to file written statement on behalf of the substituted defendants. Now, my lord, lordship will kindly come to page 26. Your lordship's order of 17th April 2025, second paragraph. Learned advocate for the substituted defendant has taken out a written statement as there is objection On behalf of the plaintiffs, with regard to the filing of the written statement, as long period have passed, the substituted defendant is granted an opportunity to take out an application in this regard. Now kindly turn the page. I write a letter to my lord, the plaintiff's advocate. Madam, by order dated such and such, my client above named has been substituted and as is added as party defendant in the caption suit in place and state of the original defendant number 1. I have received instruction from all of them to represent the said substituted defendants in the said suit. As such, you were requested to supply a copy of the cause title of the last amended plaint of the instant suit. Then, my lord, it was not done. Even after receipt of this letter on 23rd April, kindly turn the page.
Yes, 28.
28, my lord, your lordship's order of 7th May. Then, my lord, kindly turn the page, my lord. This was on 7th of May. My lord, kindly turn the page. 14th of May. The last annexure, my lord.
29 page.
Page 29.
Yes.
Kindly see the date at the top, my lord. 14th May 2025 at 13:10 hours. Oh, sorry, my lord. The date is 11th of May. I'm sorry, my lord. I get confused.
No, page 29.
Page 29, yes.
Yes.
Kindly come to.
This was communicated 11th May.
Order was communicated. Order was not required to be communicated because the order was passed in their presence.
Yes.
Then, my lord, kindly come to the letter that by a letter dated such and such, I had requested you to provide a copy of the amended cause title of the instant suit so that my client can comply with the order dated 17th April 25 passed by the Honorable by your lordship. However, in spite of such request, the copy of the cause title was not supplied. Such fact was also highlighted before the Honorable Court on 7th May. When the matter appeared before the Honorable your lordship, my lord, in fact, the learned counsel appearing on behalf of the plaintiffs had made a submission that a request will be made by him to you to supply such amended cause title. I am not aware, though, whether such request was made to you or not, but the fact remains that as of today, the copy of the amended cause title has not been supplied by you.
Yes.
Now, my lord, under these circumstances, it's a formal application, my lord, according to me, for extension of time to file the written statement.
That's all.
That is all, my lord. If I am required, my lord, I can rely on Supreme Court decision, my lord, which says, my lord, that yes, justice has to be done. My lord, there are several judgments, but I would like to rely on, my lord, only one judgment reported in.
No, regarding service of summons, that is regularized. There was some latches that is regularized. Only it is your, because it is your application, not for dismissal, but for filing the written statement. So, yes.
My lord, only one judgment, my lord. May I hand it over to your lordship, my lord? It's reported in 2008, volume 11, Supreme Court cases, page 769. Kindly come to paragraph 5.
Oh, this is there. This is the original written statement. Anyway, this is applicable with regard to the written statement at the outset and subsequent this amended additional written statement.
I have a better ground, my lord.
Yes. May not be strictly applicable.
I have a better ground.
Yes, that is para 6.
Para 5, 6 are the facts, my lord.
Yes.
Kindly come to paragraph 6. The appellant was the defendant in the suit for partition and separate possession of agricultural land such and such. The plaintiff respondents number 1 to 5 have also sought for a declaration to the effect that a will dated such and such executed in favor of respondent number 6 was illegal, null and void, and was also for permanent injunction restraining the appellant from making any construction over the open land. Now kindly come to paragraph 13, 1-3. Considering the facts and circumstances of the present case and the statements made in the application for condoning the delay in filing the written statement, we are not in a position to hold that the appellant was not entitled to file the written statement even after the expiry of the period mentioned in Proviso to Order 8 Rule 1 CPC. After reading the provisions, in particular the Proviso to Order 8 Rule 1 CPC, we are unable to hold that the provisions under Order 8 Rule 1 are mandatory in nature. In Salem Bar Association, it has been clearly held that the provisions, including the provision of Order 8 Rule 1, are not mandatory but directory. It has been held in that decision that the delay can be condoned and the written statement can be accepted even after the expiry of 90 days from the date of service of summons in exceptionally hard cases. It has also been held in that decision that the use of the word shall in Order 8 Rule 1 by itself is not conclusive to determine whether the provision is mandatory or directory. The use of the word shall is ordinarily indicative of mandatory nature of the provision, but having regard to the decision in that case, the same cannot be construed as directory. Then, my lord, paragraph 20 is set out. Paragraph 15, my lord, kindly come to. Therefore, following the principle laid down in the decision as noted herein above, it would be open to the court to permit the appellant to file his written statement. If exceptional circumstances have been made out, it cannot also be forgotten that in an adversarial system, no party should ordinarily be denied the opportunity of participating in the process of justice dispensation. Therefore, unless compelled by express and specific language of the statute, the provision of Order 8 Rule 1 CPC or any procedural enactment should not be construed in a manner which would leave the court helpless to meet extraordinary situations in the ends of justice. In keeping the principle as laid down by this court in Salem Bar Association in mind and in view of our observation made herein above, we now look into the averments. Now, my lord, here, my lord, as I have already submitted before your lordship, that the leave was granted to the original defendant number 1, my lord, to file the written statement. I have been added as a party. I am entitled to file a written statement. The cost title was given to me now. I would, my lord, kindly give me, my lord, some time. I shall file the written statement. Substitute. Okay. My lord, those are my respective submissions.
Yes.
Before I proceed, I just want to clarify. I just took the instruction regarding the letters written by my learned friend's client, my lord, on page 27 and 29. Just my learned friend said that the cost title was provided. And in the letters, it was indicated to provide the cost title, not the plaint. So that should be clarified. And it was already provided. Otherwise, this application could not, my lord, be filed today by the defendants. Now, my lord, I'll just show, my lord, 2 paragraphs and the principle of Order 8 Rule 1. Kindly comes to page 10, para 8 of their application.
Yes.
Well, it is an admitted position that the writ of summons were lodged and they have received it. Well, issued on 20th March 2017 on the original defendant number 1 and was received by the original defendant number 1 on 28th March 2017. So there is no dispute. They have admitted that. Now, my lord, the principles of Order 8 Rule 1 requires, my lord, the reasoning why such delay, because at para 12, I'll rely on the para 12, my lord. The reasoning they have given for the delay, my lord, that I think, my lord, is not acceptable. Kindly comes to para 12. However, the original defendant number 1, being an octogenarian lady, fell seriously ill and could not affirm the said written statement within the time stipulated, nor could take any steps to prefer an application for extension of time to file the written statement thereof. The health of the original defendant number 1 did not improve with time and was finally constrained to appoint her younger son, the deponent herein, to affirm the written statement for and on her behalf. Such written statement was finally affirmed on 4th March 2019, but by such occasion, the time to file the written statement had expired. My lord, I pause here for a moment. The written statement was affirmed on 4th March 2019. From that day itself, if I take into account, there was no application. There was no application of any sort for extension of time to file the written statement. So time starts from there. But in any case, if I take the principle of order 8 rule 1, my lord, the time has already expired. Now, my lord, kindly follows it, my lord, but by such occasion, the time has already expired. However, before any application seeking condonation of delay could be drafted and filed, the original defendant number 1 became seriously ill again. The pandemic set and consequently the original defendant number 1 expired on 10th April 2023. Well, it kindly takes the time period. On 4th March 2019, it was already expired. No steps taken by them to file any application. Now, the pandemic set aside, my lord, and till 2023, my lord, the defendant number 1 expired. Now, after that, my lord, there are several orders by this honorable court where, my lord, the substitution took place, my lord. I took steps in the matter, and today, my lord, I have already supplied the cost title. My lord, I will not stand in the way, but my lord, following the principles.
Documents annexed to this to show the illness. Any medical documents?
Nothing has been annexed. So, my lord, I'll not stand in the way, my lord, since it is a partition suit, my lord. But in that case, my lord, kindly appreciates the principle of order 8 rule 1, my lord. And since no cogent grounds have been stated, my lord, I'll pray for cost. That will be my submission.
Yes.
Apropos, my lord, what has fallen from your lordship, my lord, my learned friend, is relied on paragraph 12, page 11. Kindly, my lord, come to paragraph 12, page 11.
Yes.
However, the original defendant number 1 being an octogenarian lady fell seriously ill and could not affirm the said written statement within the time stipulated, nor could take any step to prefer an application for extension of time to file the written statement thereof. This is first. The second is health of the original defendant number 1 did not improve within time and was finally constrained to appoint her younger son, the deponent herein, to affirm the written statement for and on her behalf. Such written statement was finally affirmed on 4th March 2019, but such occasion the time to file the written statement had expired. However, before any application seeking condonation of delay could be drafted and filed, the original defendant number 1 became seriously ill again.
Oh, just 1 minute. So far this point is concerned, it was affirmed, was any advance copy served upon the plaintiff's advocate?
My lord, the whole difficulty is, my lord,
any averments that you served a copy?
There is change of advocate, that is the whole difficulty. Copy is there.
Anyway, it is silent whether the copy was served or not.
It's silent. But only thing is, my lord, kindly come to their affidavit in reply. They do not deny any of these facts. Had they denied, my lord, I possibly would have annexed, my lord, the document. Kindly come to page 9 of their affidavit in reply, which has been filed today. Paragraph 8. They are family members, my lord. They know.
Paragraph 9.
No, page 9.
Page 9.
Paragraph 8.
Yes. Page 9, paragraph 6.
Reply page 10. With a key though. Sorry, my lord. Opposition.
Reply is yours.
Yes, I'm sorry, my lord. Opposition, yes. I made a mistake. I made a mistake. Sorry.
Yes, page 8, paragraph 6.
Page 9, paragraph 8.
Yes.
Lordship got that?
Yes.
My lord, it deals with paragraph 12. Naturally, my lord, they don't deny any of these facts. That, my lord, the original defendant number 1 was an octogenarian lady, that she fell seriously ill and was unable to affirm the written statement. Thereafter, she again fell ill. None of these statements are denied.
Yes. No. What I was asking you, whether you have annexed the medical papers of the illness. Definitely, what is the relation between your client and the
Family
plaintiff?
members.
Family members.
Yes. That is why, my lord, they don't deny. They know, my lord. মামলাটা কর
So it's concluded.
Lordship. So far as, my lord, my learned friend speaks about cost, my lord. It's, my lord, entirely on your lordship, but I would humbly submit that, my lord, really, my lord, today, the heirs of the original defendant number 1, my lord, were not at fault. They were substituted. Unless, my lord, the substituted, my lord, cost title is served, they really cannot, my lord, proceed.
The matter has, anyway, it is still prior to this thing hearing stage.
Yes,
The
yes.
trial has not started.
No, no, nothing has been done.
That is, there is no, it has not come to that trial stage.
No disclosure of document, nothing.
Anyway, yes.
My lord, may I have your lordship's leave?
Yes. Mr. Mitro, learned counsel for the applicant defendant, and Mr. Banerjee, learned advocate for the plaintiff, are present. You are for all the defendants?
No.
Oh.
1A to 1D.
1A to 1D.
Mr. Mitro, learned advocate for defendant number?
1A to 1D. Substituted
1A to 1D. And Mr. S. Banerjee, learned advocate appearing for the plaintiffs, are present. Heard learned counsels on GA 13 of 2025. The hearing of the application is concluded. Let it appear for orders on Three 7/2025.
Grateful.
Affidavits in opposition and affidavit in reply filed be kept
kept
with the
on.
record.
My lord is pleased to make it CAV, my lord, for.
Yes, I will pass the orders on 3rd of
Yes,
July 2025.
Grateful.
Reserved, my lord.
Yes. Order is reserved. হ্যাঁ না ঠিকই আছে এটাই এই জাজমেন্টটাকে ঠিক করে এর মধ্যে ইয়ে করে দেবেন না আর এটা ইয়ে করে দেবেন কালকের মধ্যে পাঠিয়ে দেবেন আর কি না জাজমেন্ট মানে এটাই তো ফর অর্ডার্স হবে তো 3 তারিখে এটা আলটিমেটলি কালকের মধ্যে চেম্বারে পাঠিয়ে দেবেন হ্যাঁ ফর অর্ডার্সে থাকবে 3 তারিখে
Adjourn motion, item number 25.
I beg to appear for the applicant, my lord. My G application.
GA is your application.
Yes, my lord. Mr. Ali is my lord.
I appear for one of the joint receivers.
You are appearing for?
I'm for the my lord, G applicant. My lord,
Applicant, what, administrator?
No, no, not administrator.
It's a
My lord, it's a
Oh,
it's a
Mr. Ali,
Devattar
you
estate.
mentioned this matter.
Yes.
Item 25.
Item 25.
Yes, you are appearing for?
Well, I'm appearing for the respondent in the GA.
It's a suit, my lord, regarding a Devattar estate, my lord. The suit has been disposed of, my lord, long back. Several order has been passed, my lord. Receiver has been appointed by this honorable court. May I, my lord, take your lordship to the orders, my lord?
What are you seeking in this application?
My lord, my prayer A has been already allowed, my lord. I'm, my lord, seeking, my lord, transfer of Seva Puja, my lord, to one group of Sevait to another group of Sevait. That has been allowed by the coordinate bench of your lordship, my lord.
This is?
Yes.
Prayer A was allowed.
Prayer A was allowed. Now, my lord.
Prayer B?
Prayer B, my lord, court has directed the joint receiver to file a report regarding the accounts of the Devattar estate, my lord. A report has been filed by the joint receiver, I believe, my lord, and an exception has been carried out by one of the joint receiver. The difficulties is, my lord, advocate on record of both the side has been appointed as a joint receiver. Now, my lord, I don't know, my lord, the receiver has signed in the report, and he has also carried out an exception of his own report.
Copy of the report is served upon
Copy
the
of the report has been served.
Whether it is filed, that is the question.
I don't know, my lord. The report of the receiver has been filed long back.
Joint receivers, I have
Yes.
my report back. It is on record.
Another receiver is not present before the court, I believe, my lord. Is not present. Now, my lord, exception has been filed.
Yes, report is filed.
Regarding the, yes.
My lord, the exception has been filed.
Exception filed by you.
Pursuant of the order of the court.
No,
to the joint.
exception to the report is filed.
Yes, no.
Exception to
Exception to
receiver
the
report.
report is filed. Yes, my lord.
Yes.
Well, this is. Well, there is one typographical mistake that has to be corrected. However, I should
This
clear.
exception application is to be decided.
Yes.
Yes.
Well, that is all with regard to the prayer B. In connection with also, well, taking together the joint receivers report.
Lordship can fix it any other day. We'll come back.
No, in the
Yeah,
exception application is taken by Mr. Ali's client.
Yes.
So did you file any, are you supporting that or you
No,
are?
I'm not supporting that.
So
Yeah,
have
my
you filed your
only-
opposition? If you-
Lordship allow, we'll file your
No,
opposition.
question is
Yes.
either you have to support or you have to.
Well, no, I'm opposing the same. I'm opposing the same.
That means you are supporting the receiver's report.
Yes.
So you file an
yes,
opposition.
I'll file an opposition then. Now, my lord, there is a conflict of interest, my lord.
Opposition.
One hand, my lord, receiver, joint receiver, my lord, they are, my lord, filing the report before this court in terms of the order. And my lord, again, my lord, receiver is carrying an exception to his own report.
Then I can, if you suggest, I can appoint a third receiver.
No,
from
That
the,
will
from the
come
part.
back. That will come back.
So
that
that
will
will
come back.
resolve the
But I am
controversy.
part altogether removing the receiver because the state cannot bear. Well, there will be no Kali Puja because from the reserve, the puja has to be done.
You have to, you have to see that the revenue is increased.
Revenue cannot be received.
No, you have to see, explore the possibilities.
It is a DT, my lord. It is a DT.
But
Yes.
with my learned senior's leave, I am one of the joint.
She is one of the receiver.
Yes, Malad, the present status is that there are two accounts of this Debottor estate. Malad, one is the fixed account and Malad, one is the current account. Malad, in the fixed deposit account, only 5 lakh rupees there, from which an interest of Malad nearly 24,000 accrues each and every year. Now, Malad, what my learned senior friend is saying, I believe, Malad, that the cost of this Sheba Puja, Malad, that is even not covered with this interest. Now, there are receiver charges also. Malad, we are also in difficulty. Our charges are not being paid, and Malad, we also cannot break that account, Malad, and take our money. So that is also one difficulty. If your lordship kindly decides on this, and this particular receiver's report to which my learned senior friends has carried out an exception, this report only says what are the charges that have accrued for both of the parties.
Okay, anyway, if your learned friend is supporting the receiver's report, let him file an opposition.
Well, she
I'll file.
is
supporting
advocate
the
on
receiver's
record of
report.
my learned friend.
Yes, but that
A
is the
receiver.
difficulty. I have pointed out
Receiver.
the thing, my lord, very outset, my lord, the difficulty is the court has appointed both the advocate on record as receiver.
That means
With
that is
remuneration.
the
With
yes,
remuneration.
that
yes,
means
that.
yes,
they have to
of course.
justify that. They have to justify the report.
Yes.
So let him file opposition.
My
Now,
lord, I
now
have-
it's
Your
with the
lordship will-
class of the two receiver, my lord. It's
My lord,
become a
your
class of two
There
receiver.
is no requirement.
No, no.
My lord, your lordship will kindly see the exception I have given, only one annexure I have annexed.
No, I can.
It is
One
in
thing
a
you
joint
see,
meeting, it has been.
now next time, instead of, you are now, the joint receivers are receiving monthly remuneration now.
Yes, 2,000, 2,000,
That is
4,000.
new.
Receiving.
Instead
And
that,
they,
My lord, the difficulty is this, my lord. Remuneration is given by this court. I don't know, my lord, whether receiver is actually receiving any amount or not.
It was
no, why they should be,
No.
why they should be asked to toil without remuneration.
Yes.
Unless how persons will get the
Yes.
initiative.
Yes. That is the difficulty. Well, estate is not in a
Some
position to
extent
my
they
lord,
can
bear two
render
receivers.
it is not that easy.
No, but how?
Because I am telling you,
Yes,
there is a reserve amount, my lord, fixed in the State Bank of India.
yes.
From that amount, certain interest is derived. Whatever expenditure for the entire DT and the Shobha Puja, Kali Puja, and every day's puja is to be spent from that interest amount.
No, deities interest is the
It's
primary.
not sufficient.
Primary interest is of that of the deities in a Debottor property.
Yes.
Okay. But actually,
That is the Debottor.
but you see, the receivers
is the-
cannot be
that is the-
compelled to go on
that is the-
without remuneration for a long period.
My lord,
Yes.
that is the income of the Debottor. That is the only income. The only income is from the fixed
No, you
deposit.
may be paid. We are not getting paid. That's fine. If
I'm not
court is
used
pleased to
this
decide this issue.
cross-talking, my lord.
Okay, it's better you file your
I'll file my opposition. I'll come back.
You file your
I'll come back.
opposition. Yes.
learned, Mr. Ali, learned
And
advocate.
my lord, another objection is when you have taken the charge It is only from that day you are entitled to get the.
That is your address. That is your address. When they have taken the charge, they have not opposed.
Let us do, you see, Devottar property, you see, deity's interest is the primary, top.
Primary, yes.
Okay.
Grateful.
So deity's interest is to be protected, but at
First.
yes, but
Why not?
at the same time, you see, unless you see receivers are given some remuneration, how much they can toil.
No necessary for the.
With the, how
That
how
is
they
the
will toil.
resolution, but both the parties have joined it together. That is what they have decided. I have given that copy.
Okay, let us
The
consider
party
that
would
on the
have
next day. Mr. Ali, learned advocate for defendant for opposite party.
I am opposing the.
No, you are representing.
Yes, the defendant.
Defendant number.
Five.
No, one defendant is sole defendant.
Oh, only one for the defendant and one of the joint receiver.
Defendant number.
I am the
Defendant number 5.
applicant, plaintiff applicant.
Oh, learned
Mr. Abhishek
advocate
Banerjee,
for the plaintiff applicant. And yes, you give your name and learn one of the joint receiver. Give the name dash.
I've given it.
Yes, is present. As an exception to the report of the joint receivers is taken by the defendant, an opportunity is given to file opposition to the said exception. Let the opposition be filed on or before 3rd July 2025.
Yes. Your Lordship will kindly grant me the liberty to correct that. What is that? In the
Just a minute.
correction. A correction.
Reply, if any, by 8th of July 2025. Let this matter appear on 10/7/2025.
The correction.
Yes, liberty is given to learned advocate for the defendant applicant of GA 13 of 2024.
Yes.
GA 13 of 2024 to make necessary correction in the cost title.
That is my GA, my lord. No, sir, ওটা আমার GA. আপনি তো
No,
undated. Undated কথা।
ওটা আপনার আমার নয়।
GA 13
GA 13 এর কানেকশনে। GA 13 টা তো আমার।
To the exception.
But in connection with the report of the receipt, joint receipt.
That means your exception.
In exception.
What is that application? That is also must be an application.
It is exception to the joint receivers report.
Okay. Let a learned advocate for the defendant is granted liberty to make necessary typographical correction in the exception application to the
exception to the joint receivers report.
In the exception to the joint receivers report.
My lord.
Yes, it will appear on 10th of July.
Only it is the word undated should be deleted.
Anyway, I have granted that liberty.
10 June. My lord, could it be on the 1st July, my lord?
I've kept it on 10th.
Yes.
10th. No, they have to file their opposition within this thing. 3rd July. Reply by 8th.
My lord, serial number 26th, next matter.
Yes.
My lord, I am for the defendant, my lord. I am praying for some time to file the affidavit in opposition. Only 10 days extension, my lord.
Opposing the prayer, my lord.
My lord,
Kindly
We'll
consider,
come at
my
2
lord.
p.m.
my lord.
Lordship.
Joint receiver, the correction the code.
আমি এখানে
My lord, may I be permitted to mention serial number 26?
Serial number?
26.
Serial number 26, my lord, I appear for the applicant, my lord.
Yes,
I am from the
26. GA is your application.
It is my application for restoration, my lord. Your lordship was pleased to grant them time to file their opposition within 13th of May. They did not file their opposition, my lord. Within 13th, even the time to file the reply has expired. Now, if they pray for extension of time, today I shall oppose, my lord.
Only
It is
for
a simple
only
application for
7 days,
restoration.
my lord. The authorized person who will sign the opposition, she is suffering from injury, my lord. That's why.
My lord, they ought to have
Only
mentioned on
for-
13th.
Only
Your
for
Your
7 days,
lordship
my
knows
lord.
very well. 13th was the last date. They ought to have mentioned on that date. And it is a simple application for restoration, my lord. There is a delay. Kindly condone the delay. I am ready to
Okay,
accept
how soon
any
can-
condition.
How soon can you file?
My lord, only for 7 days. Oh, within 7 days, my lord. Within
Yes.
7 days.
Record an order. Learned advocates for the parties are present. Learned advocate appearing for the defendant opposite party raised for time to file affidavit in opposition to GA3 of 2025. However, in the interest of justice, this extension is given as a last chance. Let affidavit in opposition be filed by 27th June 2025. Reply, if any, by 2nd July
Lordship.
2025. Let this matter appear on 4th July 2025.
26. Grateful, my lord.
Yes, call the fixed matter.
I am grateful.
Testamentary matters, item number 27 with 28.
I am for the caveat.
Yes, so further evidence of this.
Further evidence. Deep cover.
Yes, put your witness in the box.
Third, on the last occasion, the reason for adjourning the evidence was keeping a point pending that the witness at his own instance placed one document. It is an original and private
The question
document.
is regarding the document. You see, new documents can be introduced
Yes.
even during trial under exceptional circumstances. But that has to be done under the procedure prescribed. Okay. So without that procedure, you see,
Procedure
in
will not-
different matters, new documents are introduced. But there is a procedure for introducing new documents. You abide by that procedure and introduce the
The
document.
procedure is not mentioned in the High Court original side rules.
No. You see,
And also in the order.
anyway, very well. You make an application, whether it is mentioned or not. Your learned friend, if your learned friend,
My learned friend.
if he
my
consents to
learned
the
friend can place the procedure.
if he consents to your application that yes, it is not required, you submit the where it is provided. The rules is silent. You state it by way of
My
application.
lord, can I kindly appreciate. My learned friend is raising his objection. My learned friend, let's
See, in other cases also, we come across situations where documents are introduced, but under the proper procedure, not in this way.
The procedure to filing of the production of the document has not been mentioned in the original site rules and the order.
Anyway, very well, you state it in your application, whether if it can be dispensed with, I shall dispense with, upon hearing your other side.
Separate application.
Yes. Because you see, all these documents are introduced, okay, by this application. Different cases, many documents are being introduced. It's not your isolated case.
My lord, kindly appreciate, my lord. The witness is not a party. The provision for making the production of document, the discovery inspection is only binding upon the parties of the suit.
Anyway, you see, I am
And
not,
this is
I am not aware of this provision. You please make me aware by way of application. Otherwise, no use of arguing in this way. Either you argue, you examine in part with regard to that, you always have the liberty, you come with your application, let us consider that. Apart from the documents, if you have anything to examine, you examine. You reserve that for some other day. That opportunity I am granting.
my lord, in that case, the witness cannot file an application.
No,
why
it is from
witness?
your side. The parties, the party who is examining the witness.
Party has invited the witness.
Yes.
And the witness is voluntarily producing a document.
That is the point. That is the point.
It was the existence of this document was also unknown.
She said that she
Please,
has
please,
come
please,
to
allow me to
Yes,
submit,
she-
then you reply.
He said that she has come to give evidence on behalf of the party. So therefore, whatever she will say, whatever she will produce, that is on behalf of the party. So let the party make the application.
My lord, this is not a summons suit. At first, this is not a summons suit. The provision of a suit, ordinary suit, does not apply in this case. This is a testamentary suit. This is a testamentary suit as
Then
it
you
has
do
been
one thing,
transmitted.
let me fix this matter for arguments on this point, and thereafter you proceed to examine the witness.
That can be done.
And definitely, you come with your application. Without application,
I am just taking 2 minutes, your lordship. In a suit, in an ordinary suit, commercial or otherwise. In a suit, the summons is to be issued upon the defendant. And at the time of presentation of plaint, he has to put a list on which documents he is relying upon. The copy of the relied document which are available to the plaintiff at that point of time, he has to place the copy with the plaintiff.
No use of making this argument now. Lordship has suggested-
I am
No,
explaining the
why?
position.
Why?
different points of law cannot be decided.
Why my learned
Without
friend
an
is so
application.
afraid about my submission?
I am very much afraid of you.
No,
I am
it's
just
not a
raising-
question of, it's not a question of depriving you, but let it be done in a proper procedure.
But this is a testamentary suit where it became transmitted as contentious case
Anyway,
and a
if you show me-
testamentary suit upon my affidavit only.
Anyway, on your
Affidavit in support of my caveat.
yes, if you can show some authorities that
Without
it is,
an application, let it this point.
no,
are
let
good.
it be by an application. So why your client is not available here now?
No. Who will make the application? She is residing in Ahmedabad and also
She has
suffering.
come from also Rajasthan. No problem.
She is immobile.
Okay,
That
then
is
let us
her-
do one
for
thing.
that, for herself.
So
she
let
can-
us, yes, let us consider this point of law on some other date.
Yes.
My lord,
Application can be made well and good. Otherwise, let us consider this point.
my lord, I tell you, lordship,
For argument on that point.
Come with your written notes of arguments with authorities, both of you.
my lord,
I'm not telling you to file application, but come with your written notes.
That I
Yes.
that definitely lordship can do it. But the point which was raised by your lordship, that make an application. Now he is saying that his client cannot make application.
His client is not available now.
It's not matter. Now it can be notarized from anywhere in the world.
Yes. In original.
Anywhere. It is not a problem. One need not come to Calcutta to affirm an affidavit.
My lord, the
Therefore,
caveator has become bedridden. They're suffering in paralysis.
Paralysis.
He is
Let
suffering
her
in
say so,
paralysis.
that
He cannot
she is lying in bed.
He is paralysis, but he is giving instruction.
She is giving instruction. But these are all
If he can talk to
excuses.
it,
These are all excuses. My lord, let us
There is
proceed.
no difficulty
Let us
to
proceed
a
on the
free
basis
instruction.
of the settled procedure. Whatever is required to be done in terms of law, that has to be done.
Kindly disclose the settled procedure. I will
I
not
do
wait.
not know any procedure. You come with an application.
If
then
you
I
do
will-
not know why you are raising your objection, the very funny thing, my lord,
So
my
you
learned friend does
you
not
want
know
to want to
provision.
examine with the witness
Let
today.
it be fixed for argument. Any day for argument.
ওই যে এই পয়েন্টের
Yes.
So he is unable to prove today
Anyway, both of you come ready. Learned advocates for the parties are present. DW,
The notes about
one is
advocates.
also present in court today, as the question of law is raised with regard to the production of a new document which is not disclosed. The parties seek time to come ready for arguments on
Look,
this issue.
my lord, may I just
Yes.
normally any argument is filed either in written mode or verbally.
Yes.
That is on the basis of certain
Certain prayer.
application and prayer. What is the prayer? My lord, kindly ask your lordship direction to file application. If they cannot file, then
The
your lordship will
original
see.
side, in the original side
Original
of this
application,
Honorable
that
High
your
Court,
lordship will
the
consider
prayer
only
can
and
be,
that-
this prayer can be made. This prayer can be made orally. For that formal application is not
Kindly give
required.
direction, we will see to it.
This is not an issue in the suit, my lord. This is not an issue in the suit for which I have to apply with a formal application.
This is your exercise of a right, okay, to adduce
Yes,
evidence.
yes.
So if you want to exercise any right, okay, under the law, and you want to pray for some permission, you have to make an application.
This is witness cannot apply, my lord.
Witness
That
need
is
not
the
apply.
difficulty.
No, parties
And
have to
if-
apply.
Is to apply.
Yes,
And if
parties. On this issue. So shall I fix it for application or you will argue the issue?
কি করবো বলো argument
why they are not making, participating in an argument?
What's the point in making an application? We are in any ways going to argue the matter.
This is mere will be a formal action.
Will only delay the matter, nothing else. Ultimately, we have.
Actually, he can make a petition, but provided you don't take any time for filing your opposition.
I will not file any opposition.
In that event,
I
so that the
will
matter is not
argue in law.
only the matter. The
Yes,
matter should not be
lordship can
further delayed.
record. Lordship can record.
Yes, petitioner.
The practical difficulty should be considered, my lord. It will delay the matter on.
Very well, I shall see on the next
It
day.
will delay the matter.
The petitioner is the defendant is granted liberty to file necessary application in this regard. Let this and serve a advance copy. Let this matter appear on
কি আগে অর্ডারটা শেষ করবেন বলে দিচ্ছি।
okay.
তো
1st July. Just a minute.
My lord, since she is residing a resident of Ahmedabad, suffering in paralysis,
How much
it's
time?
very difficult to. I have
No,
to
how much
draw-
time you require? You tell me.
My lord, may I give another shortest suggestion?
Yes.
And a short suggestion is that
Let this
let
suggestion.
us need not go into that complication. Let his client disclose the document which she wants to rely on.
So where is that provision, my lord? This is my difficulty.
But even then he does not agree.
Then
My lord,
it's better you do. It's better. Let your client make an objection with regard to this issue, maintainability. On from your side, objection, petition of objection regarding this issue. Let us hear this.
no,
matter.
I have already objected
So,
yesterday.
so instead of him granting the permission, it is better for you to take out an application for objection.
Yes. And that should be a reasoned objection.
In that
You
case,
file an objection, let him deal with that.
Yes.
Because it is.
then your lordship has to record.
No, I'm recording that.
Yes, record your lordship order. He wanted to rely on certain document which is not a disclosed document. I
And,
am objecting
got
to.
Let the objection be by way of petition in writing and be served upon the other side.
My lord, before, may I take only one question from
No,
whose
apart from
custody-
the
only
documents-
whose custody this document?
No, not now, no.
Apart from
He
these
is
documents,
subjected to produce.
okay, apart from this document, you put whatever questions you like today. I am granting you that liberty.
Only the question of custody.
No, not this.
From whose custody this document?
Regarding this document, you cannot ask a single question. If you
Anyway,
are
I am
interested, the
exempting
question
your
goes
client
on.
as because he is raising the objection, let him file a petition.
My lord,
Grateful.
I'm grateful to your lordship.
Petition করবো নাকি?
Yes.
Petition করবো।
এটা পড়ুন তো অর্ডারটা একটু।
My lord, a petition,
My lord, enough time is being wasted, my lord. No petition from my side is required. Lordship, keep it for argument any day. We will satisfy your lordship that without disclosing any document, one cannot rely on that.
That is better. You take out an application.
আমি কেন করবো তোমার application আমি করবো।
Objection.
আচ্ছা ওটা কেটে দিন, ডিফেন্ডেন্ট ইজ গ্রান্টেড লিবার্টি, ওটা কেটে দিন। Arguments on the issue. আচ্ছা, let this matter appear on
Point clear.
আচ্ছা এই দেখুন
ফান্ডামেন্টাল
ওই দেখুন তো 1st 2nd জুলাই এরকম ফিক্সড আছে কিনা, ফার্স্ট বা 2nd জুলাই।
টাইম ইজ বিং ওয়েস্টেড।
First or second or third.
করে দেবো আজকে।
Kindly
Now
put it on
take it.
third, my lord. Third July.
Third or fourth.
Third or fourth, any day.
3rd জুলাইতে আছে কিছু দেখুন তো।
আমি একবার দেখে নিই। ওরা করবে না তো প্রমাণ।
Third
এটাই তো
any day. Third, fourth, any day.
তিনটের সময় 3rd জুলাই 3টের সময় আছে কিছু।
3rd জুলাই হবে। গোয়িং টু পুরী।
আচ্ছা, so 3rd July will not be available.
করে দেবো আজকে আর্গুমেন্ট করে দেবো।
No, he will third.
My lord, may I do one thing?
Yes.
Let me argue the matter today itself.
You see, this is we take some time, okay?
I can argue the matter.
Okay, I'm keeping it on 2nd. 2nd also will not be available.
2nd I'm available.
At 3 p.m.
Third, my friend, learned friend is available.
No,
on
no.
third.
2nd July at 3 p.m. you will be available.
3 p.m. 1st July.
No. 3 p.m. 1st July.
1st July anytime.
If it is 3 p.m., I have.
Okay. 7th July. 7th July at 3 p.m.
1st July any.
2nd July, 3 p.m. is
ভাই মিলে
available.
তিনজন আমরা
7th of July.
Then in that case 8th July. 7th I will not
8
come.
তারিখে দেখুন তো।
8th July. Either 1st or 8th.
Okay, 8th July at 2 p.m.
2 p.m. But I can make the argument today itself.
Come with your written notes, okay? Both of you. Argue the matter and submit your written notes.
Just do at 2 p.m.
এই
Yes,
admissibility
8th of
of
July
this
at 2
law.
p.m.
8 July at 2 p.m.
Admissibility
I'm
of
grateful.
this law.
रिक्वेस्ट करना चाहिए
The second.
थोड़ा नहीं
হবে না 2nd July হবে। আর বললাম তো 8th July.
Item number 29.
एक मिनट वकील साहब, एक बार मैं एक शब्द कहना चाहता हूँ।
Yes. Item 29.
एक minute. On the one point, should the witness come on that day?
No.
While
if
it
we-
speaks for the
My lord.
argument.
Let the witness come, my lord, because the only reason.
Filing of that.
Because if you
objection.
want some instructions, she can give you the instruction. Otherwise, it will cause some difficulty.
She is not my client. She is the witness of my.
No. If you want to take some instructions, of course, from the client you can take instruction.
No, only because of that, your lordship. My learned friend is filing an objection.
No objection. I am not filing any objection.
Both of you come with your written notes of arguments, argue the matter and finish it off.
Only regarding this point.
On that day, witness
But,
is not.
Suppose,
if-
for example, on that particular date, okay, I'm not able to take a decision. I may defer the matter for 1 or 2 days.
Yes,
It's
that is-
better you wait for that day. Whatever instructions you want to take, you take it within these dates, and let the arguments be heard on that date.
But yes, insofar as remaining questions, if any, that can be proceeded today.
I also granted him the permission to do that he can do
So,
apart from that.
if he says that he does not have any other question to ask, only this question is to be made, in that case, the case is different.
That is serial will break.
No problem. Serial will break. What serial will break? One document.
The other questions are related to this document.
Fewer.
Other documents are related to this. Other questions related to these documents.
Fewer also related to this.
Fewer or let the remaining questions be made.
I will take only 1 day.
Okay.
to conclude my evidence.
Okay, you just
After this point is
you
settled.
come ready with your arguments. Let us see on that day.
I'm
If I can give you protection under law, I shall consider.
And I'm not calling him.
I had given three suggestions, my lord. One is today itself the argument can be made. Number two, without going into that paraphernalia, let him disclose this document by a letter that I want to rely on this document. That is the procedure.
And taking.
And take inspection.
Thereafter.
And he can proceed with the argument. This is the procedure. We do lot of documents, we bring lot of documents during the trial. And the procedure is, we all should, so that the object is, the other side is not taken on surprise.
Okay, you see, if during this period, the procedure, okay, as laid down by law is also kept open. I'm just not observing in the order. If you take a decision after discussion with your learned friend, the matter can be resolved also. What your learned friend suggests.
Let him, my lord, let the matter.
I have kept it as
To
a
solve
argument.
the matter,
My lord,
solve
let-
the matter, I am ready to agree. But I don't want to make this provision for it to be carried out in for future. In all the cases. As there is no such provision, let my friend show the any of the provision for protection of document by the witness.
That means what your friend suggested, at present you are not willing to go by that. You want the point of law to be decided. Very well, the point of law will be decided. Because your learned friend
Let us
suggested,
think.
because there are other cases also in such the documents are introduced, disclosed,
It will be delay.
and thereafter it is
all
relied upon.
one letter, one line letter.
Who will issue the letter?
Then
The
it is
question of person who will write the letter or
advocate,
place the
you will
letter.
write. You being the advocate, you will write.
How can I disclose on behalf of my
Very well,
client?
I shall consider that point on that day.
কোনোটাতেই হবে না, ওইটা তো করতে পারবে।
Yes, come on that day.
Item number 29.
Yes, 29. আচ্ছা, যেটাকে ইয়ে করে দিচ্ছি, অর্ডার করে, এটা অর্ডার করে দিন তো। None appears for the petitioner. Let this matter stand. Let us stand at John Till. Thank you. 9/7/2025 as the last chance.
Item number 30.
30 also same order.
All suits, item number 31,
Not today,
32,
not today,
33,
not today,
34,
not today,
35,
not today,
36,
not today.
37,
Hey, orderটা দেখি, last order. Yes, record an order. None appears for the parties when the matter is called on. Although today is fixed as a last chance, stop. Let administrative notice be issued upon the parties and their learned advocates. Let the matter be fixed on 2nd August 2025 for report.
item number 38.
Your Lordship, in this matter, the advocate record of the plaintiff. At presently, he is not out of India. He gone to USA before his daughter, before her daughter. Your lordship, kindly make place the matter any day after 10 July. Your lordship.
Yes, this is
Lordship,
an
one
old suit,
indulgence.
but you are not appearing for a long time.
In this matter, Lordship, appearing behalf of the Lordship, the respondents, the defendant number one, Mr. Tarashankar, the last occasion is a Lordship also, the given directions already, the matter will appear today, and in the meantime, communicate, I am filing the affidavit of service, my lord.
You are for the plaintiff.
I am for the plaintiff.
No procedures, and already there is a, my lord.
Yes, you are appearing
Lordship,
for.
I am appearing for defendant number 3A. My lord, on the last occasion, I had prayed for liberty to file a fresh wakalatnama since the erstwhile advocate on record is no more. My lord, their office
You are
has.
for the substituted defendant.
Yes, my lord. My lord, that liberty has to be granted.
Yes, record an order. Learned advocate for the plaintiff and learned advocate for defendant number 2A.
3A.
3A, you are appearing for?
Defendant only, defendant one.
And learned advocate for the defendant number 1 are present. Learned advocate for the defendant number 3A seeks leave to file the Vokalatnama, which is allowed.
In the department.
Allowed, let the Vokalatnama be filed in the department. As prayed for by the learned advocate for the plaintiff, the matter stands adjourned till.
My lord, the wakalatnama is here. May I be permitted to file it today, here and now?
Department কেটে দিন liberty is granted to file the vokalatnama in department যেটা কেটে দিন
এটা নিয়ে নেবেন
যদি তারপরে কি লিখুন লাস্ট
লিভটা দিয়ে ঠিক জিনিস দিয়েছিস তো আমি খুলে দেখলাম না কিন্তু
be filed as prayed for by the learned advocate for the plaintiff, the matter stands adjourned till.
PIC,
I'm keeping it on 23rd of July. 23/7/2020.
May it be recorded that I have already filed the wakalatnama.
7/2025. ঠিক আছে? Let the Vokalatnama be which is filed.
23rd Lordship, instead of 23rd July, can it be Lordship subject to the 24th July, my lord? Subject to
23rd এর জায়গায় ওটাকে 24th করে দিন।
My lord, I am deeply obliged, my lord.
Let the Vokalatnama which is filed be kept, be kept with the record.
ওখানে আমাদের ইনফরমেশন দিতে হবে রেকর্ড করে দিয়েছেন
Kept with the record.
kept with
Yes, I have recorded that. The Vokalatnama file be kept with the record.
My lord, it in the suit ledger it has to be entered. So my advocate on record is.
So if you want that, you file it in the department. Then let me delete that. আচ্ছা,
leave may be granted to
ওখানে
file.
লিখুন তো liberty be granted ওইখানে যেখানটা দেওয়া হয়েছিল।
ইন্ডোর্সমেন্ট করে দেবেন। লিভটা দিয়ে দিয়েছে।
না প্লেন্টিভ না ওইটা না ওই ডিফেন্ডেন্ট 3AA
আরে তার মানে কি ডিফেন্ডেন্ট take steps in time.
Let the Vokalatnama be filed in the department. Yes, I have recorded that. Let the Vokalatnama be filed in the department. আচ্ছা, instead of 23rd it is made 24th.
Lordship, I am deeply obliged.
23 না 24 করে দেবেন।
Much obliged.
দিয়ে দিচ্ছি আমি দিয়ে দিচ্ছি আমার দাদা বোকাটা পেছনে
I'm deeply obliged.
Item number 39.
Yes, not today.
Item number 40,
Not today.
41,
Yes, not today.
My lord, item number 42, I am appearing for the plaintiffs, my lord. My lord, we've come to learn that the defendants have passed away, my lord. So, my lord, we'll be praying for 2 weeks' time to take appropriate steps in that regard, my lord.
Yes, record an order. Item 42. An advocate for the plaintiff is present and submits that one of the defendant has passed away. Stopped. Thus, liberty is granted to take necessary steps. Let the matter But can't take necessary steps. Let this matter stand adjourned till 10/7/2025.
I'm leading Ms. Bhattacharya. Can it be, my lord, a week thereafter? Can it be after 17th? We'll take some time, my lord, to because it's
22,
very well.
22/7/2025.
Very well. Great.
আগেরটা দেখুন affidavit of service file be kept with the record. যেখানে ডিফেন্ডেন্টের ওকালতনামা বলেছে ওটাতে affidavit of service file be kept with the record. Case call 45.
For framing of issues, item number 45.
My lord, both the parties have submitted their
I'm
suggested.
praying for a short passover. I am being led by Ms. Manali Bose. She is on her way, lordship.
Let it be not today.
Yes, then let it be not true.
Because 3 p.m. there is a fixed matter. So let it be not today, okay?
My lord,
45.
instead of tomorrow, could it be kept sometime next week then? Because
What will
tomorrow
not
I'm
be
in some
taken up, implied. Because Friday, usually second half, this appellate side matters are
Yes,
taken up.
yes.
Lordship, she's on the
But
ground.
not today. Acha, not this week. Item 45, not this week.
Grateful to lordship.
Grateful.
সময় 3 p.m. এ এখনো কেউ 3 p.m. এই তাহলে আমি একটু 10 মিনিট পরে বসছি আর কি ডেকে দিন একটু আছে
আর 40
3টের সময় আবার ইয়ে Yes, call the fixed matters.
Number 43, fixed at 3 p.m.
Yes.
Witness is here. নামটা কি?
Extreme indulgence. I understand my learned friend's matter will
UDHA.
for some time. The witness is here.
দেখো
But
স্পেলিংটা
the
দেখো
next matter is ours.
Yes, yes.
My lord, no, my lord, there also the witness action was proceeding. But pursuant to an order that has been passed by the Honorable Division Bench only yesterday. I understand our matter now is coming within the, my lord, purview of the Commercial Courts Act.
Then this matter has to be released.
It has to be released, and I was praying that your lordship will kindly direct the department to, my lord, take adequate steps to convert the matter, because I'll tell you,
Cannot
lordship.
be done.
Actually,
It has to be dismissed.
No, not at all.
All orders are void.
Section 15, pending matters are to be transferred.
Then you
Cannot
come with
be.
an application, let him
Come with an
contest that.
application.
This is a question of law. It's
This is the point.
pursuant to.
This is my order 7.
There are, your order 7 rule 11 is pending.
I went to Supreme Court. You know, we were in Supreme Court. Supreme Court said, why have you filed an order 7 rule 11 after so many years? So I, my lord, told Justice Dotto that I will ask 3 questions in the suit. And I dispose of the order 7 rule 11. I'll ask 3 questions and decide the suit. You know, I'll just read out, my lord. The limited petitioner is landlord.
No, order 7 rule 11 on what ground?
Commercial suit. Same point. What he wants, my lord, to be converted.
So
This has
no,
come up, yes.
you filed that when? After 2016 or
No,
before?
my lord, I'll tell you, lordship, this matter, this judgment,
Suit is
that,
23.
if I may,
Sorry,
after,
sorry,
if I may.
Sorry,
please.
Shonendra.
Suit is of 2000?
But suit is of 2013. My lord.
2013, that means
yes.
prior to the Commercial Courts
Yes,
Act.
yes, my lord, I'll tell you, lordship. Then, my lord, I'm sorry, I've taken up my learned friends out of
Okay,
turn.
just
my
2
lord, I'm
minutes.
saying. My lord, then this suit is based on 106 of the Transfer of Property Act. My lord, your lordship knows the cause of action starts when the defendant refuses to. My lord, that is a statutory right. It was held that if it is a statutory right under 106 of the Transfer of Property Act, then, my lord, the interpretation of the lease and the agreement would not be required. But this judgment of the Honorable Division Bench, which has come up only yesterday on the 18th of June 2025, it is saying that no, in case of a suit which is filed under 106 of the Transfer of Property Act, in order to know the validity of the notice, the interpretation of the agreement.
Yes, there were 2 different views of this coordinate bench.
Yes.
And matter was referred to the division bench.
Yes, my lord. Now, my lord, this Honorable Division Bench, only yesterday the
That
judgment
is presided by Justice Sen.
Justice Sen. Now it is saying that this nature of suit also is encompassed, it's coming within the Commercial Courts Act, as it is coming within the definition of section 21C subsection 7.
So your learned friend wants your suit to be dismissed, let him argue.
Let him argue, yes.
No, your learned friend, you see, had
Yes.
there been no objection, I would have released the matter and directed conversion.
They had wanted the suit.
They want your suit to be dismissed, so let him submit.
Today you cannot.
They had.
I'll just indicate.
May I finish? Okay. They had also made an application under the provision of Order 7 Rule 11 on the ground that we had
No,
filed.
at best, on his submission that I can at best do, take his application under Order 7 Rule 11, hear you for your release, hear your submission for your release, and pass an order on the Order 7 Rule 11.
Order 7 Rule 11 application is not
That's
pending.
why I want to read the order.
Order 7 Rule 11 not pending.
No, Millard, may I read it? Millard, in Supreme, it's pending. In Supreme Court, what did
Anyway, it will take some time. You better come ready with your arguments.
Yes.
Or you see, in different places, different courts, you see, of course, in High Court, it is not required. So far, the district courts are concerned, if a suit is to be transferred, but it is not transferred, the litigants come with an application.
Well, here, with respect, section 15 of the Commercial Courts Act is very clear.
Yes.
If it is pending, then it would get transferred.
But in that provision also,
Yes.
sometimes arguments are raised. Suppose defendant files a petition that yes, or this should be transferred. The plaintiff says, no, it is not a commercial in nature. Then the court has to come to a findings. Yes, it is commercial or non-commercial, and thereafter transfer.
Here, my lord, with respect, the plaintiffs have come up with the plea, which the defendants had once come up, that this is a suit which has to be filed under the Commercial Courts Act.
Anyway, then you come ready because it will
Then,
take
as your lordship
it will
pleases.
take some time.
Your
because I have a
Honor,
fixed
My
matter.
witness has also
I
not
will
come.
also argue that nothing of this nature can be done because Supreme Court has directed, we request the High Court to make sincere endeavor to dispose of the civil suit within 6 months, subject to its convenience and subject to cooperation extended by the parties. If any unnecessary adjournment is paid for by the tenant defendant, High Court may deal with it appropriately. Submission of Mr. Jishnu Chaudhary, learned senior counsel, appearing for tenant defendant, that its petition under Order 7, Rule 11, 1908 will not be pressed. And inter alia, the tenant defendant proposes to put questions to the witness for the landlord plaintiff in the course of cross-examination on the aspect of maintainability of the suit are recorded. Now today, it is not open to transfer, to do anything. We have to go to trial as per order of Supreme Court, and I'm going to put questions on
Okay,
maintainability.
record an order.
My lord, apropos this submission, my lord, was this, or to put a question to myself, was this order of the Honorable Division Bench then existing?
Doesn't matter.
It does matter because this is the law.
I shall
We'll
consider.
argue.
My lord, whatever I get, if I pursue with the suit,
Now the suit is to be dismissed.
ultimately, my lord, it will be construed that it's whatever orders I've got are void because it's
Anyway,
beyond
let's come back.
jurisdiction.
We're detaining somebody else.
Let me hear you pass an
As your
order.
lordship pleases.
Whoever you see, any of you are aggrieved, you have a higher forum.
Yes, my lord, that is not there. We are here to
Learned,
assist your lordship.
Mr. Ghosh, learned advocate for the plaintiff, and Mr. Ishnu Chaudhary, learned advocate for the defendant are present. Mr. Ghosh submits that the suit be released and be converted as the dispute involved is commercial in nature. But
Pursuant to the order passed.
in view of a judgment of the Honorable Division Bench, in view of the judgment passed by the Honorable Division Bench, in the matter or in the reference of GA Com 2 of 82 কে দেবেন ঠিক আছে 82 কে দেবেন Mr. Chaudhary, learned counsel for the defendant, objects to the transfer and submits that an application under Order 7, Rule 11, CPC is pending, and thus this bench has to decide.
Has not been pressed.
It is pending, but he will not press it and will put questions to the witness in terms of undertaking given to Supreme
Submits
Court.
that
And it's not that he will be deprived of that opportunity.
the suit is not maintainable and is liable to be dismissed, and in terms of the order of the Honorable Apex Court, his client has liberty to put necessary question with regard to maintainability in cross-examination. Stop. In view of the submissions of the learned counsels, the matter stands adjourned till.
Of course.
Yes, when shall I keep it?
Whenever your lordship pleases.
With your
For dismissal of the suit.
with your written notes and compilation of any judgments you want.
Yes.
Learned.
My lord, written notes.
Yes, it's an
I'll
important
make
point of
my-
law. It can go up to the Apex Court also.
Yes. It will. Because
week
now
time.
in terms of order of remand, he has to continue.
Learned counsels are requested to come with written notes of arguments along with the compilation of the judgments. Let this matter appear on এই 3rd July কি দূর 3rd July?
Yes.
3rd July. Okay, on 3rd July
Yes.
at 3 p.m.
As your lordship pleases.
That may it be the 4th if it's possible. My learned friend is not there on the 3rd.
See, 4th is a Friday. There's some uncertainty. Friday, second half, you see, matters
Yes,
are not
yes.
taken up.
তাহলে 7 জুলাই
আচ্ছা 8 তারিখে দেখুন তো 8 তারিখে 3টের সময় আছে কিনা 8 তারিখে 8 তারিখে তাহলে এটা 8 তারিখে ওটা 3টের সময় করে দিন তাহলে
No, I am in
ওটা কি
Bhubaneswar.
8 তারিখে দুটোর
No,
সময়
not
আচ্ছা
Yeah,
তাহলে
not the 8th, please, my lord, I am not there.
7 তারিখে
7th is fine. Or the 9th, my lord, if it's possible.
Earlier the better, my lord. 7th, if it's
No,
possible for my
you
lord.
want the matter to be just listed in the usual course, that is one thing, but
No,
if it is
it's
to be
fixed,
fixed.
yes,
Heavy
yeah,
argument.
yes, yes.
থাকবে কোথায় যাবে
কত তারিখ আছে? পরচুলে তো শুক্রবার, ওটা তো সেকেন্ড হাফে তো আর হয় না।
সন্ধ্যেবেলা আসি, এবার কি করবে সারাদিন সারাদিন
দেখ ওই সময়টাই দেখুন,
তুমি পরিষ্কার করবে নাকি?
সেকেন্ড জুলাই দুটোর সময় আছে।
Nobody is interested.
আচ্ছা আচ্ছা, দুটোর সময় সেকেন্ড জুলাই না? তাহলে সেকেন্ড জুলাই থাক 3টের সময়। সেকেন্ড জুলাই at 3 p.m.
2nd July, 3 p.m.
Second.
2nd July. Obliged, my lord. And we have to come with the written notes.
Yes, yes.
Oh,
written
God.
notes and
I'm
any-
very sorry, my lord. 2nd also, I'm not there. My lord, please keep the original date. If my learned friend is not there, I'll manage. Please let it be on 3rd July.
আচ্ছা যাক, ওটাকে
Third করে দিন ওটাকে।
সেকেন্ডের জায়গায় থার্ড করে দিন।
Third করে দিন।
আর 3 p.m.
3
Don't
p.m.
bother. Grateful. You
Let the
don't
copy
touch
of the judgment be with in your
So
lordship.
let the copy of the
let that
judgment
be-
file be kept with the record.
Yes. The judge shall be copied.
Item number 44.
43.
Item number 43.
আসো এদিকে আসো।
কত নম্বর ছিল?
ওটা 44 হচ্ছিল, এটা 43 এবার তো
পিছন দিক দিয়ে হচ্ছে নাকি?
আমরা মেনশন করলাম।
ও আচ্ছা।
দেখো, বুধাদিত্য ঘোষ। হ্যাঁ, ঠিক আছে, আসতে বলবো, অসুবিধা নেই।
Yes.
দাঁড়ান এক মিনিট।
Can you conclude today?
বুধাদিত্য ঘোষ,
Unfortunately, it would not be,
DITYA
but next day we will.
GHOSH ঘোষ।
Okay. Because today you are getting actually up to 4:30. In
Yes.
some of the dates, the courts rise at 3:30. That is why I'm asking you.
Some of the documents which are not there, which should be available next occasion, that's why just one more day.
Yes.
When you give bunch of documents, please tell my law what it is. We'll know it.
এক্সিকিউট হয়নি, এখন হবে। লাস্ট দেখো কত নাম্বার হয়েছে দেখে রাখো। My lord, these are the certificate of enlistment issued by the Kolkata Municipal Corporation in favor of Japon Guest House, proprietor Govindo Ghosh, the plaintiff, at premises number 30F Mirza Garib Street, Kolkata 16.
Kolkata 16,
16. From the years 2003-2004 up till 2009-10 collectively.
কি হয়েছিল লাস্ট দেখছি ওরা দাঁড়া।
Yes. Let it be marked exhibit.
কত হয়েছে লাস্ট? আচ্ছা, আর 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 আর
Just to curtail time, this was given as one.
আর আর collectively, হ্যাঁ?
RR collectively.
This document, tell my lord.
My lord, this is the money receipt issued by the Kolkata Municipal Corporation Amusement Department. Amusement Department. On 8th of June 2004 to the plaintiff in respect of Mrs. Japon Guest House for giving permission to the guest house for using TV music up to the year up to 31st of March 2004 at premises number 30F Mirza Ghalib Street, Kolkata 16. An amount of rupees 8,000 was received by the Kolkata Municipal Corporation in this regard.
Exhibit SS, হ্যাঁ? আলাদা হবে, হ্যাঁ? আস্তে আস্তে বলুন।
এটা পাঞ্চ হবে। My lord, these documents relate to the demands raised by the Kolkata Municipal Corporation Water Supply Department to Mrs. Japon Guest House, proprietor Govindo Ghosh, from the year 2004 till 2011 regarding regarding money for annual fees for supply of water for domestic sales of water for non-domestic purpose.
For
Domestic sale of water for non-domestic purpose. And also for water connection and extra road restoration. Demands, these are the demands raised by the Kolkata Municipal Corporation.
These are the demands raised by the Kolkata Municipal Corporation
in respect of Japon Guest House at premises number 30F Mirza Ghalib Street, Kolkata 16. And also the receipts money receipts issued by the Kolkata Municipal Corporation from the year 2004 till 2011 in respect of the said premises possessed by the plaintiff in respect of the
Possessed by the
same premises in possession by the plaintiff. Collectively.
এটা আলাদা হবে তাই তো এটা আলাদা প্রশ্ন করে স্যার স্যার এটা আলাদা প্রশ্ন করে একটা এটা বলে আলাদা ডকুমেন্ট আলাদা প্রশ্ন করে একটা করে এই দুটো এটা এক্সিবিট টিটি হুম বলুন এটা কি
My lord, this is the bill issued by the Kolkata Municipal Corporation Drainage Department in respect of Japun Guest House at premises number 30F Mirza Ghalib Street. Owner Govindo Ghosh, the plaintiff. And this is the bill for annual charges for drainage and sewerage service. Annual charges for drainage and sewerage service for the years 2006 and 2007 respectively. For using the services of the KMC Drainage Department collectively for the year 2006-2007.
You.
There are a whole lot of documents, but I will review the scenario. If these documents, although in the judge's brief there is not more. All these are part of the judge's brief. Yes. This suffices, then maybe start my arguments on next day. I just need to put certain points and conclude. So both together, examination and arguments. Next day, yes. Examination, I'll just keep it for 1 or 2 and then I'll finish up. Just to wrap up. I'm showing you this document. Please tell my lord what is it.
My lord, this is a letter issued by the Assessor Collector, Kolkata Municipal Corporation on 29th of January 2005 to the Tenants and Occupiers Association of 30A to 30F Mirza Ghalib Street on 29th January 2005, asking all the tenants and occupiers and possessors of the premises number 30A to 30F Mirza Ghalib Street, Kolkata 16, to pay their respective taxes to the Kolkata Municipal Corporation, and also a sum of rupees 1,64,300 was paid by my father Govindo Ghosh, the plaintiff in this case, vide check number 025016
025
016 HSBC Bank. HSBC Bank.
Drawer Bank,
Drawer Bank, HSBC Bank was paid to the Kolkata Municipal Corporation in respect of premises number 30F Mirza Ghalib Street, Kolkata 16, and another sum of rupees 11,880 was paid by my mother, wife of Govindo Ghosh, was paid by check number 025024 on 21st January 2005, Drawer Bank, HSBC Bank. This sum was also paid to the KMC in respect of municipal tax, was also paid to the KMC in respect of municipal taxes owed by the plaintiff. Yes, in this document, the plaintiff Govindo Ghosh's name features in the list in page number 142.
Can identify that and insert.
Yes, my lord, I can identify.
One
Page number 142.
blue pencil. Witness encircle the name with blue pencil. Witness encircle the name of the plaintiff with blue pencil.
Can be marked as exhibit U.
You হয়ে গেছে VV collectively, হ্যাঁ?
This concept of
My lord, these documents are the demand notices for the year 2006, sorry, from the year 2006 to 2010. These documents are the demand notices from the year 2006 to 2010 regarding issued by the Kolkata Municipal Corporation Advertisement Department to my father in respect of Japon Guest House at premises number 30F Mirza Ghalib Street, Kolkata 16. The demands were raised in respect of license fee for advertisement and advertisement tax on various dates from the year 2006 to 2010, and also permission fee for using hoardings and glow sign boards, for using hoardings and glow sign boards for advertisement purposes of Japon Guest House at premises number 30F Mirza Ghalib Street, Kolkata 16 on various dates. And money receipts were also issued from the advertisement department, KMC, or Kolkata Municipal Corporation, for giving permission to use advertisement for in respect of Japon Guest House. Money receipt cum license. এটা collectively. এটা হবে collectively.
double collectively.
My lord, these are the various bills issued by the Kolkata Municipal Corporation Drainage Department on various dates from the year 2006 to 2000, 2006 to 2010, from the year 2006 to 2010, for annual charges for drainage and sewerage service in respect of Japon Guest House, proprietor Gobindo Ghosh, or person liable for payment, Gobindo Ghosh, the plaintiff in this case. And also, money receipts were issued by the Kolkata Municipal Corporation for paying the charges as demanded by the Kolkata Municipal Corporation from the year 2006 to 2010. For the services rendered by the services rendered by the KMC. বাবার নাম লেখা আছে গোবিন্দ ঘোষ। মার্ক করবো বলনি তো মার্ক করবো তো XX collectively, My lord, these are the various demand notices and money receipts issued by the Kolkata Municipal Corporation Water Supply Department on various dates from the year 2004 to the year 2011 in respect of Japon Guest House, at premises number 30F Mirza Ghalib Street.
This is also collectively. That is demand notice and the
Demand
payment
notice and money receipts.
money receipt on the demand.
On the demand.
Yes, collectively.
Collectively. For using water services, water supply services from the KMC in respect of water supply services from the KMC in respect of Japon Guest House at premises number 30F Mirza Ghalib Street, Kolkata 16 on various dates from the year 2004 to 2011.
Why? Collectively.
Collectively. I may pause here, Your Lordship, and next day I'll.
Yes, record an order. This is PW1.
PW2.
Your Lordship, no, he's
Okay. Learned advocate for the plaintiff is present. PW2, what Ghosh? PW2 Budaditya Ghosh is present in court. PW2 is further examined in chief and discharged. Documents filed are marked exhibits. On the prayer of the learned advocate for the plaintiff, this matter stands adjourned till. দেখুন তো Yes, how soon can you come ready?
next week or week after that, whichever is convenient.
2রা জুলাইতে 3টের সময় কিছু নেই তো? দুই বা 3 তারিখে? আচ্ছা, আর 2 তারিখে? তিনটের সময় নেই। Okay. 2nd July at 3 p.m. At 3 p.m.
কথা বলার ছিল, আমার একটা রিট পিটিশন ফাইল হয়েছিল।
আপনার উকিল বাবুকে পাঠান।
উকিল বাবু আমাকে বলেছেন আপনি আগে কথা বলুন
না
তারপর।
না, আপনার উকিল বাবুকে পাঠান। আর রিট পিটিশন ছিল কি এই ঘরে ছিল, এই কোর্টে ছিল? আপনি ওনাদেরকে স্লিপটা দিয়ে দিন, ওনারা দেখবে এটা কি মামলাটা এখানে আছে কি নেই।